Yes.
May I have my lord's leave to mention a matter, my lord? This is Civil Suit 55 of 2008. My lord, I had first mentioned it on 15th of January for hearing of a GA application. The affidavits are complete. On
Still
15th,
not in the list.
no, your lordship directed it to appear today. Yesterday, my person was informed that the records have gone to Khidirpur and they have not been recovered from Khidirpur.
রেকর্ডটা না থাকলেও ম্যাটারটাকে লিস্টে দাও। লিস্টে দিলে তো আমি একটা অর্ডার করতে পারবো। আমি তো একটা অর্ডার করে ডিরেকশন দিতে পারবো। কালকেই লিস্টে দেবে এটা, কারণ রেকর্ড খুলতে 1 বছর টাইম লাগবে। আমি ডিরেকশন দিয়ে সেটা 3 দিনে বেরোবে।
May I hand over the paper to your lordship? But they say the records are in Khidirpur because they are old records and
I know
Khidirpur
how
put
to
out.
bring it from Khidirpur.
Your lordship knows, my lord. Your lordship will kindly do what is necessary, my lord.
লিস্টে যখন দিতে বলেছি লিস্টে দেবে, রেকর্ড পাচ্ছে কি না পাচ্ছে সেটা আমি বলিনি। কালকে যেন লিস্টে থাকে। কাম টুমরো,
I'll come to.
আই উইল চেক ইট।
I'm grateful to you.
Origins are listed matters. Item number 1. Lord, I appear for the plaintiff petitioner in this matter. My lord, this is an application for recalling of your lordship's order with by an order dated 23rd of February 2020. The suit was dismissed. My lord, it was served on the last occasion. I filed the.
Have you served on the other side?
Yes, yes. My lord, I have filed the affidavit of service. The respondent
Where
number,
is that?
defendant number, on the last occasion it was filed. My lord, respondent number 5 to 8 has been served. My lord, defendant number 1 was represented by an advocate, my lord, who refused to accept. Thereafter, my lord, it was sent to them directly. My lord, they have refused to accept that.
Issues were framed.
Yes, issued by
When it was dismissed?
23rd of February 2023. Issues were framed, my lord. The plaintiff's first witness was being examined.
Condonation of delay?
The condonation of delay has not been filed, my lord. I have to file that. My lord,
Come tomorrow. Adjourn to? How long would you take?
my lord, 1 week, my lord. In the meantime, I will take the condonation of delay application.
এটা নিয়ে দাও। 26th February
Yes, my lord.
or little bit earlier?
A bit earlier, my lord.
আজকে কত? 16? 16.
Item number 2.
May it please your lordship, my lord, application in respect of a Devottor estate, my lord. Now, my lord, previously, my lord, an application was filed.
GA18 is for?
GA18 is for passing, my lord, necessary directions. Lordship will find that this application has been made by, my lord, the Shivites, who were appointed by your lordship's order dated 16/5/2023. Your lordship's order is annexed.
Just a minute, let me go
Yes,
through
my
it.
lord.
Four Shebaits were selected from four branches
Yes, my lord.
to assist the receiver.
Yes. Now, my lord, the erstwhile receiver, my lord, expired. Now,
That
my lord,
we
as
have
a result
stated.
of which, my lord, both, my lord, the branches, my lord, came up with an application, my lord, for appointment of my lord and receiver, my lord. Now, my lord, my learned friend's application was, my lord, to appoint from the bar. My application was, my lord, to be appointed from the, my lord, Shevites. Now, my lord, your lordship has passed an order on 19 September 2022.
Recorded lawyer of both the parties.
Milord, I am now, Milord, representing Milord the present Shevites, who has been appointed by your lordship. Your lordship will find that order
Now, Mr. Boran and Mr. Dotto were appointed
as the joint receivers.
joint receivers.
Yes. Your
They were
lordship will
assisted by named
be
Shebites.
assisted by the Shevites.
Named Shebites.
Name Shevites in terms of your lordship's order.
Now, what do you need?
Now, Milord, the difficulty is what Milord, Mr. Boral and Mr. Dotto is facing. Your lordship will find that from page 24 onwards, because Milord, while executing their job, they are finding Milord practical difficulties, which has been Milord more fully enumerated from page 20 onwards. Milord, to the branch manager, it's a Milord covering letter written by both the joint receivers. Milord, all those letters are there.
What was the order, earlier order?
Yes, Milord, your lordship will find that at page 16. Milord, the main crux of the Milord order, your lordship's order, is at internal page 2 at page 17, Milord. The joint receivers shall discharge their function diligently, reasonably, and for the benefit of the estate. Now, my lord, for that, my lord, while my lord executing their my lord job, say for example, my lord, when they my lord go before the bank, the bank says, my lord, there is no specific directions upon my lord the joint receivers to carry out in a my lord in a way, my lord, the joint receivers want, my lord, for the my lord for protection of the estate. Your lordship will find that.
What do you need? What part of order do you
Yes.
need?
Now, my lord, that is, my lord, my prayer A and B. My lord, A, I am seeking, my lord, for confirmation of their, my lord, appointment. And B, my lord, in order to, my lord, function, my lord,
That
properly,
is in para 11.
that is in para 11. I'm grateful to your lordship.
Instead of confined within para 11, it is
Yes.
better to say to administer the estate in a full form.
In full form.
Basically, to administer the estate, to administer the income, collection of income, outgoings. This the administration of estate means all incidental,
All incidental. All incidental.
including opening of bank account.
Everything. Everything. My lord, for the protection. That is the reason why your lordship, my lord, has categorically, my lord, recorded at page 17 of your lordship's order, the joint receiver shall discharge their function diligently, reasonably, and for the benefit of the estate. My lord, we as lawyers, my lord, can understand, my lord, the interpretation of this order. But, my lord, outsiders, my
There
lord,
must be something specific.
yes, my lord.
GA 18 of 24 is filed. praying for passing incidental orders to the earlier orders of this court, by which the present joint receivers were appointed and entrusted with administration of the estate, of the Devottar estate. Devottar estate of
Sri কোথায় প্যারাগ্রাফটা বল মানে নাম প্যারাগ্রাফ 1 শ্রী শ্রীধর জিউ এন্ড
হ্যাঁ,
শ্রী
দেবোত্তর
লক্ষ্মী
estate of-
ঠাকুরানী
এই যে এইটা দেখুন, এই যে ফার্স্ট প্যারা দেওয়া আছে, শ্রী শ্রী শ্রীধর জিউ and শ্রী লক্ষ্মী ঠাকুরানী, installed and located at
কলুতলা
60 Kolutola Street, Kolkata 73.
60C presently 60C milord.
No, you have mentioned 60.
Milord, originally it was milord 60, now it has been milord changed.
Where
as
have you mentioned?
milord paragraph 6?
Same is known as
Yes.
60C.
Yes.
Presently known as 60C, Kolutola Street, Kolkata 73. Full stop.
কি আর objection আর বেরিয়েও বা কি এটা তো for the administration.
In terms of order dated 16th May 2023, the present joint receivers were appointed who were to be assisted by the Shebaites named in the said order.
আরে এটা দেওয়া মানে এটা
Full stop. The joint receivers were to discharge their function diligently, reasonably, and for the benefit of the estate. By a subsequent order dated 19 September 2022, joint
That-
receivers were allowed to administer the estate and operate the bank account for a limited purpose.
yes.
Next para. This application is filed praying for further order under which the joint receiver can fully administer the estate. Follow my dictation.
Yes, Milord, only one thing, Milord, your lordship has recorded subsequently by an order dated 19/9/2020, but 2022 order was, Milord, previous to 16/5/2023 order, Milord. Milord, first was 19th September
yes,
order.
yes. Previously, 22 বললাম না, previously ওটা, sorry. Full stop. Next para, the joint receivers, Mr. Kinjal Kumar Boral, advocate, and Mr. Ochinto Kumar Dutt, advocate, প্রেয়ারে দেখে নেবেন বানানটা, joint receivers, comma, assisted by the named Shebaites as in order dated
16th May 2023.
16th May 2023, shall continue to administer the estate of ওই শ্রী শ্রী ঠাকুর জিউ যেটা ওটা লিখবেন at 60 by C or 60C?
60 capital C. ও হ্যাঁ
No, no, 60 by C.
বাইসি আলাদা 60 বাইসি কারণ বাইসি হলে হচ্ছে তোর পার্টিশন
You have mentioned two things. One is 60C, another in
Yes.
prayer 60 by C.
Sixty by also known as Maulana Shaukat Ali Street. কি এটা কি নম্বর রে 60 ক্যাপিটাল সি না 60 বাই সি বাই সি ইউজ মিলট
সব জায়গায় রিপোর্ট করতে হচ্ছে 60C হয়ে গেছে বাট অরিজিনাল ইট ইজ 65
Milord, I'm told, Milord, originally it was, Milord, used as 60 by C. Thereafter, Milord, everyone used as 60C, and then, Milord,
You'll be in problem then,
Milord, I understand,
because
Milord.
bank will follow my order. There will be a total mismatch.
60 by C, লেখালে হবে?
Or come tomorrow.
60C
60C, Milord, 60C.
Then you come tomorrow or day, any other day. Any other day.
60C, Milord, one of
Yes,
the
then it should be rectified.
should be rect. Because
60C
Anyway, লিখে দিন। থাক,
এখানে
লিখে দিন।
লিখেছিস কেন 60?
60 Cs. Anyway, I'm continuing.
My lord.
60C, Polutola Street, so and so. ওই তারপরে লিখে দেবেন also known as
Shaukat, Maulana Shaukat
Shaukat
Ali
Ali Street,
Street.
কলকাতা 73. কি বললাম পুরো সেন্টেন্সটা বলুন?
joint receivers Mr. Advocate and Mr. Ochinto
দত্ত না, ডাট।
joint receivers assistants device has been ordered by 68 2023
Hmm.
to continue to administer the state of 3C
Collect income and deposit the same in bank account. Pay outgoings. And shall in other ways manage the estate as may be necessary and incidental reasonably.
প্যারাগ্রাফ 11 এটা তো আরো হাইট গ্রাফ হয়ে গেল।
And shall take all necessary steps as may deem fit and necessary including opening of bank accounts, investing income in appropriate scheme,
হ্যাঁ ওটা তো
paying outgoings, salaries, and other liabilities,
হবে।
collecting incomes, incurring expenditures, and properly arranging for performance of Shiva Puja,
7 ছোট কথা শিওর
comma, semicolon, all the things necessary and incidental for performance and management of palas
ওটা তো রিসিভারে নিয়ে পারবে
shall deal with the government officials and departments of the government and shall also represent the estate to the government and other outside agencies. Have you filed any statement of accounts?
Statement of accounts, my lord, my lord, the joint receivers, my lord, could not gather all, my lord, the documents.
At least because I have to fix remuneration.
Yes,
So
yes.
that's
My
why
lord, that is the reason why, my lord, one of, my lord, the appointed Shebite is present over here. I asked him, my lord, they said that they have decided amongst themselves for the time being that it should be fixed at a sum of rupees 14,000, my lord, to be divided by the joint receivers for a sum of rupees
7,000 each.
Per month.
For the time being, the joint receivers shall receive remuneration at a rate of rupees 7,000 per month each. Full stop. The joint receivers shall submit a statement of accounts and report on the estate on or before the returnable date before this court. Let the matter appear in the list on how long would you take?
My lord, কতদিন মোটামুটি লাগবে একটা statement of accounts?
1
My
month.
lord, 1 month minimum, my lord. Or else, my lord, your lordship can April and monthly list. My lord, lordship kindly keeps it in the monthly list of April, my lord. Because, my lord, what impression, my lord, what I was given is, my lord, a huge task, my lord.
Statement of accounts as on 31st March 2024. The matter will appear in the list on 30th April.
30. Grateful.
GA
GA
18 of
18 of
24 stands disposed of accordingly.
Grateful, my lord.
Item number 3. But I appear for the petitioner, my lord. This is application for recording the death of some of the defendants. The dispute arose, my lord. The difficulty arose.
Who is the plaintiff?
I appear for the plaintiff. I am the plaintiff. Now, I have
Just a
annexed the
minute,
death
just a minute.
certificate of one of the deceased person.
The
other death certificate was not available with us. So, my lord's last order records the direction on the corporation to produce the death certificate. Now,
Lord, I'm
she's appearing for the corporation, man.
Mr. Gopal Chandra, led by Mr. Gopal Chandra Das, my lord,
Where is
on
he?
behalf of regarding his tooth pain, my lord. He
But
is
I'll
not
tell you the
coming.
difficult. The gentleman did not die in Calcutta. So the corporation is unable to give a certificate, but we have availed up.
Let that report
Yes,
come.
she's with a certificate. She is with a report. My lord's order has been
This
complied.
photocopy will not be done.
No, it's the original. No, original report. And I have the original death certificate with me from the Greater Bombay Corporation. Greater Mumbai Corporation. I have the original death certificate with me.
This is riot in Mumbai, my lord.
Have you got death certificate?
Yes.
Then file application. Oh, that application is here.
Yes, that application
That
is.
by supplementary affidavit. Make a supplementary affidavit. I will pass order.
Lordship can keep. Nobody is opposing.
Not a case of opposing. That's a decorum. This must come in proper way.
Whatever my lord's pleasure.
Where is that?
Yes, this is the original. And I can give a photocopy also. But this is the original and the photocopy. This should have been Xerox রেখে দিও original ফেরত দিও. So my lord.
You come with the supplementary
I'll
affidavit.
I'll come. Man.
Come on the next day with the original. Come on the next day. How long would you take? Friday?
Right? Yes, yes. Monday we come back on Monday, man.
মানডে কতগুলো আছে?
Monday কি Tuesday করে? ঠিক আছে। ঠিক আছে।
16th
16 তো ছুটির দিন নাকি ওটা পড়ে যাচ্ছে না? 14-15 ঠিক আছে।
have you any plan to go somewhere?
No, I'm here. That's the reason. No, I'm here. Saraswati Pujo, I can't go out. 14-15 has to be in Calcutta. Pujo is it. May I take back the original death
Yes,
certificate?
take it back.
Oh, oblige.
Grateful, my lord.
Adjourn to 16th.
Yes, 16.
আজকে লোক দিতে বলবে, 5খানা সাক্ষী আছে, স্বাধীনকে আবার ডেকে পাঠাবো না আমাদের।
Item number 4.
But I am for the petitioner. This is an application seeking for leave to file the inventory and accounts beyond time.
দেখো তো কি আছে।
My lord, originally the grant was on 18/12/2009. I have stated in paragraph 2, page 2.
After probate is granted,
Yes. Probate granted on 18/12/2009.
where have you stated there is no willful default?
My lord, I
Have you stated anywhere that we have no willful default?
my lord, I have stated the reasons in paragraph 4, page 2.
GA2 of 2024 is filed, praying for leave to file inventory of and accounts of
In connection with PLA 293 of 2009.
who is the testator?
Testator is Jugal Kishore Tibrawal. It is a latest of administration.
In respect of letter of administration granted on 18/12/2013, in respect of estate of late Jugal Kishore Tiberwal. Full stop. Delay is explained. Leave is granted to file the instant inventory and account. GA2 of 24 stands disposed of.
Item number 5.
This is my application for restoration of a suit, my lord, which has been dismissed for default.
Who is your other side?
My lord, Mr. Bhattacharya is it.
When it was dismissed?
10 January 2020.
10 January 2023, we had come
Where
to
is-
learn of this
Where is the order?
on 23rd of March.
Where is that order?
Yes. My lord,
Oh, yes.
41 kindly
10
comes to,
January 23.
yes. My lord, kindly comes to page 41.
Just after 1 year.
No, we have taken out an application in the meantime, but 2 applications, but those were dismissed and we were directed to file afresh because of some technical irregularities. The reason being, your lordship will kindly see the cost title ones. It's International Club and Association of Persons. Now this,
Where have you explained this?
yes, your lordship will kindly have a look at. Your lordship will kindly have a look at, my lord, paragraph, my lord, 2. In fact, paragraph 1. Paragraph 1 at page 2. But it is pleaded that initially the name was an association of persons. It was Swiss Club, which was subsequently changed to International Club.
What was the stage of the suit?
We have filed our
The written statement has been filed, no further step had taken place. But the explanation really, your lordship will kindly come to paragraph 5, my lord, at page 4.
How much would you pay?
Well, I leave it to your lordship. Well, I leave it to your lordship.
Leave it to lordship.
But the difficulty, may I indicate only two things? Mr. Surojit Sen, advocate, was conducting the matter. My lord, he underwent a hip replacement surgery during the period, my lord, when the suit was dismissed for default. Thereafter, my lord, we had filed an application for restoration, two applications in fact, which were not in proper form. Thereafter, he passed away.
7 of 24.
Milord, may I just indicate one thing, Milord? The difficulty which they faced in the last two occasions, the same difficulty is today there. The plaintiff is no longer, Milord, in subsistence, Milord. In 2011, Milord, they have changed themselves into a company, Milord. Today, Milord, there is no legal existence of the plaintiff. So, Milord, how can, Milord, Milord,
Unless it is restored, I cannot take out a
have not
substitution
taken steps
application.
in 2011,
It
according to
must
their
be
own pleading.
filed.
My lord, you'll see,
Anyway,
Milord,
don't let us
Kindly sees the affidavit portion. The plaintiff
paragraph
number
4,
1 has not affirmed.
2011, they have, Milord.
There was, if the plaintiff number 1 is not in existence, then plaintiff number 2 must be in
Yes,
existence.
2 has filed the application.
But 2 is the president of international club. There
Today,
is no
Milord,
existence
today
of.
there is a
My
Calcutta
lord,
International
yes,
Club.
I
according to
understand.
paragraph
I
4.
understand. But kindly sees the affidavit portion. Who has affirmed?
Do one thing.
Yes.
You come, the application should be filed by the present person. And you must ever, because what you are doing, you are filing something in name of a dead person.
No, my lord. May I indicate only one thing? Kindly sees the affidavit portion. Who has filed this
Affidavit
application?
may be shown by one person.
My lord, kindly sees.
Here it's they also say they are representative of petitioner number 1. Milord, petitioner number 1 is not
Which is
even
presently known as, I have indicated that, which is presently known as Calcutta International Club. I have
Bimal
pleaded.
Kumar Khetawat.
Yes. He is
I
the
am
present.
plaintiff number 2
Yes, because
and authorized representative of plaintiff number 1.
yes,
Whereas
which has been subsequently, kindly sees, which has presently known as Calcutta International Club. In the body of my application, I had indicated with annexures to show that Calcutta International Club has ceased to, has changed this constitution.
Why have you made this affidavit? I am known as Calcutta International Club. You make a proper affidavit.
But Calcutta International Club is the millet company.
What is the name of the company now?
Calcutta International Club.
Calcutta International
Yes.
Club.
And that is why it has been affirmed. Unless my suit is restored, my lord, I took out a composite application. The department did not allow, my lord, filing of the amendment with this one. That
Anyway,
is why we had to change it again. Unless we restore it, we can't file it. We are in the process of filing, my lord. Our application is also ready.
legal exists, not
But our
the change of
application is
name.
also ready.
It is, Milord, the conversion from an unincorporated society to a company, Milord.
But I have pleaded that. It's not that I've suppressed anything, but the predicament is that unless the suit is restored, I can't take out his amendment application. I need to amend the plaint as well. But unless it is restored, my lord, I can't. I had taken out a composite application, but the department did not allow the filing.
They have changed themselves in 2011, Milord. The suit got dismissed in 2023. Until date, they have not taken steps.
come with an amendment allow. I will allow both.
I cannot file an amendment because, my lord, this suit is not.
Your amendment application shall be. I am passing order.
But GA 5 and 6, we had taken out application for amendment. That was also dismissed because, my lord, as withdrawn because of this issue. On technical ground.
Anyway, you file an amendment application. I am passing order.
Very well. We shall show that order and file.
Yes.
Very
That's why I am passing this
well.
order.
Absolutely. I bow down.
As prayed for, leave is granted to the plaintiff to file amendment application along with to be heard along with GA7 of 2024. Okay. Let the matter appear in the list.
Would your lordship kindly add one more sentence if it so commences to your lordship? That since the constitution of the plaintiff has changed,
I am not mentioning
the department won't allow filing of that. That is the whole difficulty.
That is my direction. That is the order.
Very.
Now, even then, if you say face any problem, you mention.
Then I'll come and mention and take leave.
Yes.
Grateful.
Appear in the list on 1st March. Department, who is not allowing it to? কে allow করছে না?
See, at that point from the master. Because that was to be accompanied by master summons
I will
and an affidavit in support
I will
thereof.
talk to him. My direction is there and that is to be complied with.
Item number 6. Item number 6.
Cost. Who is item number 6? আগের order কি ছিল? কেউ নেই? আবার ডিসমিস করলে তো আবার আসবে সেই রেস্ট্রিকশন করতে। দাও একটা ডেট দি, একটা ডেট দিতে হবে। 3rd 4th মার্চ দিয়ে দাও, 4th মার্চ দিয়ে দাও। হ্যাঁ, none appears adjourned to 4th March.
Item number 7.
This I've heard.
My lord, your lordship had heard the plaintiff. Now, my lord, I had indicated, my lord, that I would
My lord,
make my submissions today.
But I have note for the plaintiff, Lord Mr. Rohit, management who's appearing, but he's not well. But not, I'm not seeking for time, Lord. Let my friend conclude, Lord. Kindly permit us to reply, Lord, on the
Let
next.
me remember this. Remember the matter.
Restoration, it's a restoration, Lord. No, no,
It's an amendment.
Oh, this is the amendment. I'm sorry. I'm sorry.
I'll just indicate in a very
What amendment had proposed to be made?
My lord, insofar as paragraph number 17A to 17F in the body of the plaint, I do not stand in the
So
way.
Mr. Banerjee argued on some other point.
Yes, the point, my lord, that is, they have not pressed for the subsequent proposed amendment to the plaint insofar as leave under clause 12 is concerned, clause 12 of the letters patent. But they have sought to introduce a new prayer in the plaint, my lord, wherein they have sought for delivery of possession of the suit property, as well as a leave under order to rule 2 insofar as their claim in damages is concerned. Now I'll indicate that, my lord, your lordship kindly takes up page 80 of the application. That is where the proposed amendment is in the plaint.
Page
79, my lord, is the plaint wherein the proposed amendments have been indicated. Your lordship will directly go to, my lord, page 85, wherein the body of the plaint, they have sought to introduce certain new facts. But what essentially changes the nature and character of the suit, my lord, is the relief. The added reliefs which is now being sought for after 12 years of the plaint of the suit having been instituted. The suit was instituted in the year 2009 with the alleged cause of action having arisen in October 2006. Now in the year 2021, my learned friend's client take out an application for amendment wherein they seek to introduce 3 further reliefs. One is the leave under clause 12 of the letters patent. Second, my lord, is the leave under order to rule 2 of the Code of Civil Procedure insofar as their claim in damages is concerned, and the prayer for recovery of delivery of possession, my lord. Now, my lord, this is a suit for specific performance of an oral agreement. If your lordship kindly takes up the cause title once at page 79.
By introducing B1.
B1 and my lord,
It will be a suit for land.
It wasn't a suit for land. That is what my submission
Was
is.
not, but it will be a suit
It
for
will become a suit for land. Now what happens, my lord, the leave under clause 12 had not been sought for at the time of institution of the suit. Now they seek for that leave now at this juncture, at this belated juncture, after 12 years of the institution of the suit. Then they said, look here, I'm not pressing for the leave under clause 12, but please allow me to amend the plaint insofar as delivery of possession is concerned. Now, my lord, the case would actually change. It would change the very nature and character of the suit, because initially it was simpliciter, a suit for specific performance of an oral agreement. That is exactly the reason why, my lord, I'll beseech your lordship to take up page 79. The cause title
where the
of
property is located.
The property is located at Kamak Street. That is within the jurisdiction. But the purport of the suit, my lord, they are suing on the basis of a purported oral agreement. Now your lordship will take up the cause title once. None of the defendants, my lord, stay within the
Now,
territorial
even if
jurisdiction
it
of
is
the
a suit
honorable.
for land,
It is not a suit for land.
if suppose it was not a suit for land, now it is converted into a suit for land.
No, in the event, my lord, that is what I was indicating, my lord. In the event, it was not a suit for land. My lord contemplates a situation wherein it's simpliciter a suit for specific performance of an oral agreement. Both the defendants are outside. The plaintiffs in the plaint say that part of the cause of action and the negotiations have happened at the premises which is within the jurisdiction.
In that case also,
The leave under clause 12, my lord, would have been necessary because the part of the cause of action which they have pleaded has arisen within. But, my lord, in the event, they have not sought, because over here in this particular suit, they have not sought for leave
so
under
your
clause
point
12.
is in the guise of introducing some new cause of action
They are changing the nature and character of the
and
suit.
making up
And-
the loophole.
Yes. Which, at this belated stage, when the trial is about to commence, would change the very nature and character of the
Issues
suit.
are framed.
Issues have not been framed, but my learned friend, issues have been framed. No, have not been framed, but my lord, my learned friend's client has already taken out an application for appointment of a commissioner. That is GA7 before your lordship.
Commissioner for?
For my lord, recording of the evidence.
Lordship, it was submitted that we are not pressing that application because when that GA was taken out, it was COVID period. After that, it is not.
Issues are to be framed, then that will be taken up.
Now, my lord, if it is not a suit for land, I am entitled, my lord, to have an issue framed insofar as the maintainability of the suit before this honorable court. Because clause 12, unless you have prayed for leave under clause 12 and got the leave, my lord, this suit in itself is not maintainable before this honorable court. Now, after 12 long years, even, my lord, going by the Limitation Act, for recovery of possession or delivery of possession, the limitation is 12 years. Your lordship will find that the plaint was affirmed as long back as in my lord, March 2009. I'll just indicate that, your lordship. My lord, this application in itself has been taken out after 12 long years. So accordingly, even if a suit for recovery or delivery of possession would have been made out, that itself would have also been barred by limitation. I am covered by the Honorable Supreme Court's judgments, my lord, wherein the amendment which is being sought to be made to the plaint or any of the pleadings, my lord, that should not be barred by limitation. That also has to fall within the four corners of the statutory provisions under the limitation. Because in the event, my lord, today a suit was instituted as on date, even as on the date of filing of this particular application, the suit for delivery of possession or recovery of possession would not have been maintainable. In fact, my lord, my affidavit in opposition, I have annexed several orders, both of the division bench as well as of the single bench of this honorable court, my lord, wherein the plaintiff had been put on notice that you cannot cause any further delay in proceeding of the suit. It has to be heard out expeditiously. This is nothing but, my lord.
I heard you. Let Mr. Banerjee come. I'm not passing any order today.
But in that case, my lord, I need to cite a few judgments which
You
I'm
come
carrying.
with that judgment next day.
Very well, very well.
Come with that judgment.
Very well.
When
In
you
fact,
will
on the
come?
last occasion, I'll come any day, my lord, your lordship pleases.
16th,
16th.
heard in part, adjourned to 16th February.
Grateful, well.
Hopefully, Mr. Banerjee will recover in the meantime.
Yes, probably by tomorrow itself. But he's not that unwell. He'll be back.
Grateful, my lord.
Item number 8.
May it please, my lord.
What is GA18?
Lord, GA18, my lord, is for appointment of a valuer in terms of the preliminary decree, which was modified.
I'm waiting for the plaintiff, my lord.
I'm appearing on behalf of the defendant number 5, 6, and 7.
Lord, time and again, this application was taken up.
Why, what is the problem in appointing a valuer?
Lord, they are opposing, Lord, I don't know why.
First, now let me place my application.
Let him finish and then.
Yes.
Yes. Preliminary decree is passed.
Preliminary decree has been passed. In that preliminary decree, my lord, the plaintiff didn't appear. Thereafter, plaintiff had filed a modification application of the preliminary decree. My lord, I'll just show two paragraphs. Your lordship may kindly turn to page 43. The reason why this modification was done is mentioned in the, page 44, paragraph 1. The plaintiff has applied for modification of such preliminary decree on two grounds. First is it was not heard, plaintiff was not heard, and second that there can be an attempt.
That was rejected.
No, my lord, this was allowed. Now, my lord, may kindly turn to page 54 and 55, where Lord may kindly read from I direct the Commissioner of Partition appointed by the preliminary decree dated such and such to explore the possibility of effecting. Now, my lord may kindly turn down, my lord may kindly come down to the bottom. The line starts, the plaintiff will also bear the cost and expenses of the valuer. Now, my lord, the next page, why? Page 55. In the event the plaintiff is unable to bear any costs and expenses and fees required to be incurred to implement this order, that was for valuer, the modifications made herein shall stand recalled forthwith. The preliminary decree dated such and such would stand revived in its entirety in such an event. So, my lord, in terms of this order, my lord.
Just a minute. Just a minute.
Yes.
Now, what is the need for appointment of valuer?
My lord, the need is, my lord, because in the preliminary decree it was directed that the property is to be sold by public auction. Thereafter, the plaintiff had filed an application that the property can be partitioned in between the parties. So, my lord, that is why this particular valuer has been appointed to value the property and to partition it by metes and bounds.
On that situation.
It can't be partitioned by metes and bounds.
Accurate. You will have a chance. Accurate.
So the partition commissioner should be appointed.
Partition commissioner have already been appointed. The advocate on records of the parties are the
So there must be a report of the partition commissioner.
Yes, my lord, there is a report which is not available, with me, my lord, but there is a report. And my lord, even if there is not a report, my lord, then my lord, the advocate on record can sit again and prepare a report in terms of the report given by the valuer.
All right. Yes.
Ma'am, I'll finally come to page 41 of the application. Although my lord was pleased to grant me time to file my opinion of opposition, but there was a mishap in my family. I could not do it because certain records had to be brought to me in a record, without which I think this application cannot be adjudicated. Anyway, I'm pressing this. I'll come to page 41. In the circumstances, I am the view that the justice would be subserved. Last paragraph, bottom, page 41.
I have seen this.
Appointing advocate record for the plaintiff to.
So the issue is to make a proposal for partitioning of the proposed scheme of partition.
Yes.
Madam, may I? Into this order, by this order, The first, the advocate record of my learned friend's client did not appear, although he has appeared. I appeared, I made a scheme, and I submitted to the court. That scheme is not surfacing here. My learned has referred the scheme, but it's not here.
Where is that scheme?
Yes, my lord.
You have filed that?
I have filed in court.
Where is
But-
that scheme?
But my lord, that has to be brought
Let
in
me check
record.
the scheme. Let me see the scheme.
No.
Do you have a copy?
Party course, how you করেছিল?
Scheme was not supplied to us.
No, that was filed in court.
কোথায় বার করো? The scheme for partition is not placed before this court.
May I, before passing
Let
on,
that come, I will hear you. That is necessary for adjudication of the present application. Department is directed to place the scheme of partition before this court.
My lord, if my lord kindly turns to
May
page 54, your lordship will find the mention of the scheme. It
yes,
has been given by one Supriya Datta through an affidavit
Yes,
dated.
that is my client. My client is a Parkinson disease patient. My Supriya Datta, she had undergone a cataract operation. So she could
If
not.
you have submitted any scheme for partition, that
Yes.
must be placed before this court. Let that come.
May I, give me a time. I will file the entire document which I've got in my hand because the joint commissioner, by virtue of this application, my learned friend is trying to circumvent the preliminary decree.
No.
Is trying to modify it because of the fact that the joint commission of partition shall hold a meeting and will
Let me
decide.
go through the commissioner's
Yes,
report,
yes.
then I will go hear you further. Substitution is to be made.
Substitute has been done. He is the plaintiff.
I've served a copy of the plain order already.
Directed them to send writ of summons.
But that writ of summons,
Amended plaint?
Writ of summons has to be submitted.
but writ of summons will take another 3-4 weeks time.
ওখানে ইয়েটা দিয়ে দিন, আরেকটা addition করে দিন. Let the matter appear in the list on 7th March.
In the meantime, writ of summons may be supplied, my lord.
But writ of summons cannot be served because that time to take out a writ of summons is 2 weeks.
So writ of summons I cannot file my
The leave of court you can always file.
Where is amendment? Amendment কোথায় হয়েছে?
With the leave of the, you can take the leave.
Oh.
This court had directed me to serve the copy of the plaint.
We have received
So
it.
all that, I have done it. I have done it.
We have received it.
It has to be filed, my lord. Otherwise,
But with the leave of the court, you can always appear.
if my lord granted,
You seek,
my
pray for the leave,
without writ of summons.
pray leave of the,
You're appearing. Wave করে দিন।
you're already appearing.
আরেকটা কথা লিখে দিন. Amended plaint may be served upon the defendants,
I've already done, my lord.
all.
My lord,
All. I've,
File affidavit of service.
I have received.
no, I've not done my field service, but I have done it. But
It is submitted also by the learned counsel for the plaintiff
yes, my
that
lord, I've done it.
amended plaint has been served upon all the defendants.
No writ of summons.
However, without writ of summons, affidavit of service shall be filed.
I'll do that.
Was there any order to dispense with formal service?
No.
No.
Writ of
My lord,
summons has to be-
my lord, kindly want to dispense this formal service because writ of summons,
When that order was not there, you are supposed to file writ of summons.
I did, but by the time has expired.
Then you have to take necessary application for doing that. That is irregularity, procedural latches on the part of you. That you should do.
Lord, in the
I didn't get that.
The
I kindly
meantime-
condoned it, that latches, my lord.
Verbal, on basis of your verbal player, you have even not filed affidavit of service.
I'll do it, my lord.
Everything will go. You will take no steps. You will take no steps to rectify your defect.
I'll do it. I'll do it.
Next,
grateful.
Item number 9.
Mamla 7 months.
May it please, my lord. This is my application for revocation of grant of probate. On the last occasion, your lordship had asked for the registrar to give a report. Because when we had inspected,
sometimes I become confused looking at you. Which one?
this matter, your lordship had passed the order to see whether the will was there and whether the inventory and accounts had been filed. So once
The
the report,
original will is lying with the testamentary department.
It's there. So original will is there.
but it was not in the records when we had searched it, but that's whatever the report says, Manoj. And Manoj, the inventory and accounts have not been done.
No.
So
Well, the inventory and accounts we have not done, but it's ready. If your lordship extends the time, we can file.
You have to make an application.
I'll make an application. But the original will is on record.
Yes, that is the report.
So my lord will record that this report says, and my learned friend
Yes.
also admits, because that would be have some bearing on my limitation on the because the proceeding is still not over.
Now, what are your grounds?
My grounds are that I am the daughter of the deceased, and my
One
learned
is your application for revocation.
yes. But this was one of the grounds as well. So, my lord, let the report be given to us, and we'll come back.
The learned register original site submitted report dated 16 January 2024 stating therein, firstly, that the original will is lying with the testamentary department along with the probate petition being PLA number 315 of 2000. Semicolon. Secondly, that no inventory and accounts have been found entered in the ledger maintained by the department. Full stop. The learned senior counsel appearing for the respondent candidly submitted that basically you are respondent and executor.
Propounder.
I'm the propounder of the will also.
Yes. Appearing for the executor, not respondent. That will be confusing.
Yes.
Submitted that inventory and accounts have not yet been filed. An appropriate application will be taken up seeking for leave to file the same.
Well, may we have copies of the report and liberty to inspect the original will, because when my advocate inspected, it wasn't there with the PLA.
If it just records one line, that application.
Liberty is granted to Mr. Chaudhary to file appropriate application. Copy of the report may be handed over to the parties. Full stop. Mr. Ghosh, the learned senior counsel, submitted that craves leave to inspect the record and the original will. Full stop. Leave is granted. And inspection is to be made in terms of original side rules. Let the matter appear in the list for further hearing. Fifth March.
5th of March.
Any earlier date?
No, well, that 5th March is convenient.
But
With
only
liberty to mention.
my lord has written Mr. Ghosh craves leave to refer. I will, Mr. Ghosh craves leave on behalf of his client. Let Mr. Chandor go to go.
তাহলে ওটাকে একটু চেঞ্জ করে লিখে দিন ওই ক্রেভস লিভ কথাটা কেটে দিন A copy of the report may be handed over to the parties, to the learned counsels.
So that is,
for perusal.
For inspection, your lordship, that only that one line should.
Arekta, on prayer of Mr. Ghosh, leave is allowed
to the petitioner.
Mr. Ghosh, learned counsel for the petitioner, leave is granted to inspect the record, in particular the original will, in terms of original site rules.
Great.
Is it okay now?
Yes.
Item number 10, Lordship, I am for the petition.
Just a minute, please.
Lordship.
আগেরটার অর্ডার শিটটা দাও তো। রঞ্জন দেব, সরি।
Item number 10.
This is an application for
Malad, discharge of the caveat, Malad.
who is your other side?
Malad, the other side, Lordship, the last direction, Lordship would kindly peruse 5th January
You are the
20.
caveator.
No, Malad, I am the petitioner. Kindly peruse the last order, Malad, passed by your Lordship. 5th January 2024.
J5 is filed by the caveatrix.
We have filed it. We have filed the GA5. Malad, the other side has given us a letter. They cannot give us the copy of the affidavit in support of caveat. But that was directed by the last order because their clients are not contacting.
Affidavit in support of caveatটা কোথায় দেখি?
Application was served upon them. Client.
We have not received a copy of this affidavit.
No. But twice my lords directed for service. The other side appeared. And lastly,
The learned counsel appearing for the.
My lord, kindly peruse this letter once.
I'll not go into that. Appearing for the petition executor. না এভাবে দেখো GA file 5 of 2023 is filed on behalf of the executor praying for discharge of the caveat. None appeared for the caveatrix. The learned counsel appearing for the executor submitted that copy of the affidavit supporting the caveat has not been served upon him in spite of repeated directions. The department shall hand over an authenticated copy of affidavit supporting caveat to the learned counsel for the executor. Let the matter appear in the list on 26th February. I will hear you on that date.
I'm grateful.
Item number 11, Tara Properties Private Limited.
I have heard it.
No, not. I'll tell you, Lordship. My lord, this is for the main profits. My lord, my learned friends were to give a calculation sheet of what they are agreeable to, of course, without prejudice to their rights. My lord, we haven't yet got any calculation from them. If they give it to us, my lord, I can come back with instructions. If we are, it may be
ready?
possible we are agreeable. If not, my lord, we can proceed.
So that an amicable settlement can be made.
Correct. That's why your lordship had indicated.
According to them,
You give it to them. Better.
Yes, my lord, I have been given a
Because
copy.
this court will not pass order at this stage.
My lord.
It is your amicable issue.
My lord.
Mutual issue, the court will not interfere at this stage right now.
এটা বলছে ওরা যেটা ওদের যে কন্টেন্ট দাঁড়াও না যা বললাম যে
This is for the purpose of settlement, na?
Mr. Dashgupta today handed over a copy of. Should I note it or not?
Yes, lordship can note it.
But I will also note that it is without prejudice.
Yes, of course.
Because
Definitely.
my lord.
Already filled by the old.
A calculation of rent and mean profit to Mr. Mitro towards amicable settlement of the dispute. Be that as it may, since an amicable settlement is on anvil, hearing is adjourned to give it back. 1 month or 15 days?
15.
My lord, we come back within 2 weeks, my lord.
ছবি দিয়ে এটা শান্তির মধ্যে করে নিই 7 days will be sufficient.
Next week আমার একটু প্রবলেম আছে।
14 তারিখের উইকটা তো মানে সরস্বতী পুজোর উইকটা হ্যাঁ তো এই উইকটা ছেড়ে দিয়ে তারপরে
Today is 7th.
7th, my lord.
after সরস্বতী
Any
23rd?
after the Saraswati 23rd, my lord.
23rd February.
Lord, grateful, my lord.
ভালো করে এই ওটা কোথায় গেল আমি দিয়ে দিই
Item number 12,
একটু মাথা লাগলো।
item number 12, my lord. My lord, I am instructed to appear on behalf of Mrs. Shormi Dotto, my lord, who is representing different number 5A to 5E. My lord, she is under maternity leave, my lord. I am seeking for an adjournment of.
Who is the defendant?
My lord,
My lord, I am the defendant number.
You are the plaintiff.
no, my lord, I am defendant. Actually, I am led by Mr. Sanjeev Bandyopadhyay, learned advocate. Under this instruction, I am for the defendant number 2A, 2B, and 2C.
Adjourned to 28th March.
Grateful, my lord. My lord, one more thing. I was
Item number 13.
my lord, one more thing. On 20th August 2023, we applied for a certified copy, application for certified copy, but as of now, it has not been made available to us. So we were
As submitted by the learned counsel appearing for
defendants 2A, 2B, and 2C.
defendant number 2A, 2B, and 2C. Certified copy, although applied for, has not yet been available, has not yet been handed over by the department.
For this reason, we cannot apply for the transposition of
The department is directed to deliver certified copy expeditiously if applied for.
Grateful, my lord.
13.
Item
Yes,
13.
my lord. Your lordship, in this matter, I am appearing for the plaintiff. This matter has come up for computation of the mean profit. Now, prior to that,
For the defendant in this, we had approached the defendant for amicable settlement of the matter. They have proposed an amount. I have communicated to my client. If this matter could be either referred to mediation or we could out of court settle the matter.
Try out of court settlement.
Your lordship, we are trying to do it.
Come after 15 days.
your lordship, may I first submit? On 8th December, your lordship had directed us to pay us the cost. That cost may be recorded. We've paid the cost of rupees 5,000. Now, as regards the proposal, we've
communicated a figure to my learned friend. If they may
Come
agree or
after
they may
15 days.
disagree.
Come after 15 days. এটা দাও একটু। আরে ওইটা দাও না।
5,000 cost was imposed.
Yes, we paid that cost.
In terms of order dated,
8th December 2023.
the learned counsel for the plaintiff. Plaintiff submitted that cost has already been paid by the High Court Legal Services Committee. Copy of receipt and check is presented before this court. এটা দিয়ে দাও, এটা রেখে দাও। The original receipt along with the documents be kept in record. Full stop. It is submitted that talk of settlement is going on. Accordingly, the matter is adjourned to 4th March.
Obliged.
Report of the learned registrar original site dated 11 January 24 be kept in the record.
Item of 14. Lord, I have instructions to intervene in this matter. Lord, I represent, Lord, the Tenants Association. Lord, I'm instructed, Lord, that the receiver appointed, the earlier receiver appointed in this matter, Lord,
the plaintiff
constituted us. Lord, I'm not for the plaintiff. I'm an intervener.
All right, but who is for what for the parties?
I am for the erstwhile receiver, my lord. May I just indicate two things? My lord, by order dated 3rd October, if my lord does not have a copy, may I hand over a copy, my lord? By order dated 3rd October, in paragraph 3, my lord had opined. May I read, my lord? Accordingly, Mr. So-and-so, who the erstwhile receiver that I appear for, so-and-so is discharged from his duties. Pursuant to such, my lord, the newly appointed, one of the parties to the suit was appointed as a receiver. There was a direction upon the newly appointed receiver to hand over all the books and records from the erstwhile receiver. I have concluded that duty, my lord. If I may be kindly discharged.
You are for Umesh Chandra Rai?
Yes, my lord. The erstwhile receiver.
Discharge তো হয়ে গেছে।
হ্যাঁ না দেখো একটা রেকর্ডিং আছে যেখানে বলেছে কাগজপত্র আমাকে দিতে হবে।
You filed a report that you have handed over?
I have.
Have you filed that?
No, my lord, I have not filed
a report that you have handed over.
That I have handed over.
Yes, you have handed over or not?
Yes, my lord, I have.
So
it is an undisputed fact.
So keep it on record.
Lord, the difficulty is, Lord, we have been constituted by this receiver, the erstwhile receiver. Now, my lord, the new receiver appointed by your lordship, Lord, is not accepting rent or not exceeding several.
Let the new receiver appoint. Let the report come. Further order will be passed.
And Lord, may I come up with an formal application on the next?
Absolutely.
My lord, prior to my lord finalizing the order, when I was handing over the documents, I have handed over the documents under cover of a letter. This letter was received by all the parties. And I have the original of such letter, my lord. If my lord wants, I can hand over the original.
Or retain the original. Your affidavit. I am relying on your affidavit on your report.
Lord, lordship's pleasure, my lord, to record an order indicating, Lord, granting us liberty to use an application, Lord.
You have to come with application.
Yes,
that is
yes,
rule.
Lord. If
there is no question of giving liberty. Whenever it will be filed in the department, it is always come.
Lordship's pleasure, my lord, to direct the erstwhile receiver, my lord, to circulate a copy of the.
You are not a party, not now. Let the report come to this court first. Wait. He is committed to this court, not to you.
Yeah, Lord, that's why I'm praying before your lordship, Lord.
The learned counsel for the receiver. Yes. Erstwhile receiver submitted that all the documents are handed over in terms of order dated 3rd October 2023. And praise for liberty to file affidavit in this regard.
Report.
Leave is granted. Affidavit is to be filed by the erstwhile receiver on or before the returnable date. The present receiver shall be present in the court on the returnable date. Let the matter appear in the list on 28th February.
23. Lord, may I at least have, Lord, the liberty to see the records, Lord, so that I can
Not now.
Filing the application, Lord, I will require the cost title. Lord, that's why I was praying for that.
The learned counsel, Mr. Swanso, craves leave to inspect the record so that he can file necessary application for intervention.
I'm grateful.
Leave is granted and inspection is to be carried out in terms of the original site rules.
I'm so grateful. No?
Item number 15 to 20.
That matter.
Your Lordship, two different suits from 15, 16, 17 and 18.
First, let me know what is the status of water supply and lift.
Lordship, the thing is, may I just indicate one thing? What is happening here is, as per my instructions, is that the special officer had gone one day. When the special, because it is obviously with notice. In the original side, it's always they had gone by with notice. That day, a little
Who is the
bit
special officer? Where is the order?
Lordship, I am the special officer, if I may. On the 29th of January, I, after obtaining consent from all the parties, had conducted the inspection. The inspection that was to be conducted was for two buildings, both comprising of 10 floors. Carried out the directions. But I am praying for one indulgence. The report is moving to be extremely lengthy because of the number of particulars my lord has recorded in the order. Kindly grants me a period of 1 week. The report is almost concluded. I shall submit the report. Possibly this issue will be addressed.
The learned receiver, when you were appointed?
On the 19th of January. Order appointing us, no? 9 January, my lord, I was appointed. I was communicated by on the cover of a letter. 15 January. Okay, thank you so much. হুম 15-20 দেখাচ্ছে আমাদের তো 21
90
না 21
A21 This is
পরের মামলা
ও আচ্ছা পরের মামলা তুই কটাতে গেছিল
The learned receiver.
Your Lordship, may I just submit before my learned, Your Lordship? The thing is that the learned receiver, by giving notice, as he indicated, correctly giving notice to everybody, went there. Now, what the mischief which is being played is when he goes there, because the other side, they have the interveners have complete control of the meters and everything, and the pumps. They put a little bit of water on that day. Immediately from next day onwards, again it's the same situation. Again, immediately it's from the same situation. I don't have water. I don't have water for months. My tenants are going away.
Let the report come.
Yes, but the thing is, that's not going to solve the situation. All that I'm saying.
Let the report come.
Let them take an exception.
There's no
to the
question of
report, Your
exception.
Lordship.
I'm not saying that anything.
Make your submission, because right now I will not hear you. Let the report come. If what you are saying is supported by the report, then
Your Lordship, the report, that's what I'm indicating, because it is with notice. People go with notice. They will.
The point is that at the time of inspection, there may be a manipulation.
By one side, not by the.
All right, someone.
Yes.
You come. Let the report come first. Let your exception or let your objection comes. We'll hear and pass order.
Very well. Your Lordship will keep it next week because he wants one next time. So keeps after 7 days. With advance copies being paid.
No advance copy.
Otherwise, I will not know what is there in the report.
Report, he is supposed to submit the report to this court. He is appointed by this court. No advance copy. First, the court will see, then to you. Learned receiver appointed in terms of order dated 9 January 2024 is present in the court today and prays for accommodation of 7 days to file his report. Accommodation is allowed. The report shall be filed 21st February. This, he is appointed by the court. He is the officer of the court. First, he is answerable to court.
Very well, Your Lordship. I bow down.
My lord, this was apropos item numbers 19 and 20, my lord.
19 and
20.
What about 15, 16, 17?
Lordship, so far as item number 17 and 18 is concerned, Lordship has been pleased to pass an interim order at my instance, Your Lordship, on 18th of January 2023 and modify the same on 4th of July 2023. If my lord may be pleased to extend that order, Your Lordship. An interim order restraining the parties from dealing with the properties that form the subject matter of CS number 283 of 2001. That was modified on 4th of July by excluding two properties from that ambit on the ground of settlement talks that were going on between the parties. If Lordship so pleases, I may hand up the order dated 18 July and effect to the 18 July or 18 January or 4th of. Lordship 18 January order. Acha.
All right.
Fourth
It is here.
I have.
Your Lordship, may I just intervene? The item number 17 is their GA 17, which is their intervention application. The interesting thing is, see, they have their intervention application till date has never been allowed. Not heard, not allowed, and they are enjoying a interim order. They have never, they are enjoying an interim order without being added to the suit.
Where is the GH 17?
Item number 17.
Exchange of affidavit is complete?
Everything is complete, Your Lordship.
Yes, Your
Everything is
Lordship.
complete. Last day also they said they will do the hearing.
Start with 15-16.
Lordship, GA 17 is my application for addition of parties. And GA 18 is my application for interim orders. Lordship had been pleased to pass an order on my GA 18. Lordship, from the 18 January, they have gone up in appeal, but no order of stay obtained.
It was never heard.
It was heard on one occasion.
What is your locus standi?
Lordship, I am the son of defendant number 1 in the CS number 283 of 2001. I said, Lordship, this is a Mitakshara property, admittedly a Mitakshara property, and I am a...
Your allegation is against auntie and father.
Lordship, father, aunt, uncle.
And when these matters were last heard by your Lordship, Lordship felt that Lordship would start hearing with one application first. GA 16 was the application filed by Mr. Sinha's client for my lord recalling of an order. The order was passed on an application filed by the plaintiff for my lord distribution, my lord sale of the properties because the shares were admitted. Now, my lord, if my lord 16, GA 16, which is today my lord item number 16 in the list.
What is your... All right, I will hear you. What is your view on GA 17?
Your Lordship, we are opposing this because at the end of the day, if any interest, this is a partition suit which is between the brothers and the sister. If they have any cause, it is with me that they have already they under the Mitakshara.
What is your view?
Conference not
দুটো কি দিলে? Two separate AOs are there.
Your Lordship, I think they have
by the plaintiff and one is by the defendant number 1.
Bhagirathi Agarwal.
That is defendant number 1.
That is your?
Yes.
GA 18 na 17 or 18.
What is your defense?
Your Lordship, there are three defenses. One is with regard to the main thing which is there in my application for recalling also. That is that there is a property in Sevak Road in Siliguri in Sevak Road. That I say is my self-acquired property. And otherwise also, there was a partial partition deed which came up in 1975. Now it can't really be reopened today here. Now, in that partition deed, that Sevak Road property and all those have been discussed, and it was by far demarcated. Your Lordship will come to page 3.5c, paragraph 5c.
Partition deed was executed between Tarachand Agarwal,
Yes, Your Lordship.
late Dhanka Devi Agarwal,
Yes,
and two sons,
Yes.
plaintiff and defendant number 1.
Yes, Your Lordship.
Now, so plaintiff and defendant number 1, in terms of the partition deed, were owners of this property.
Yes, Your Lordship.
Now, this is a partition suit.
These are partition suit.
Between these persons.
These two and the sister.
Sister is? But she was not a party to this partition.
No.
My lord, the deed of partial partition with regard to this, my lord, we have already taken our stand when Lordship will hear GS 16, my lord. In our affidavit, we have dealt with it. It was never acted upon by the parties, and I will show from the conduct of the defendant number 1 post execution of this deed that they also had given a go by to this partial partition.
Yes, what do you have to say?
Your Lordship, we have to say, once it has been done, once the demarcations have been done, I have got possession. I say I have always had possession of those properties which whether they have acted or not, whether they wanted to do something.
I want to hear your submission.
My submission is that it has been acted upon. It was this part.
Partial partition was acted upon?
Was acted upon Sevak Road property. Otherwise, also part of it was self-acquired. Those are with me. So there is no question of the injunction also which has been asked for. What initially happened, Your Lordship, was when this partition suit was being heard. Justice Saraf passed an order whereby, by consent, all the three parties at that point of time, interveners were not there, passed an order. Inadvertently, what happened is, because my client is over 89, 87 years old, he didn't check, he was not well. At that point of time, that Sevak Road property somehow got into that list of properties to be sold. There's a court order in this that to sell all the properties and then, distribute the monies. That property got somehow in that. I had already acted with regard to that property much before. There was a company which I was a shareholder. I had given that in lieu of shares. Other transactions which had happened. There are court cases otherwise on that property. Those had acted. Somehow, inadvertently, that had come inside that order that property jointly held to be sold. So I filed an application whereby to modification of that order. That is the one which they are talking about, the modification application. I filed an application saying that this is my property. Inadvertently, it has got into here. So that's why it cannot be, that cannot be part of the sale, which for as a joint family property. That was one. The second thing, there is an appeal also by the company which actually has the property, Gagantara. I'm a shareholder. Admittedly, I'm a shareholder in that company, but that company is a separate legal entity which has filed also an appeal by saying that my property could not have been sold by way of an auction, otherwise private sale, whatever thing in a partition suit, because that change had happened prior to this. This was the situation with regard to the Sevak Road thing. So, Your Lordship, and now thereafter, what happens is, my sons, they file this intervention application saying that, oh, we are Mitakshara. It's a Mitakshara property. So at this moment, we have a right. Till before everybody was together, and their right emanates through me. Their right at the end of the day emanates through me. How they have shown that these are joint family properties is a question mark. Many of these properties may not be joint family properties also. Family businesses, doing business together, self-acquired during that business period. Thereafter, it's a partition which has been done. It doesn't say it is joint family. It doesn't say, but for something to say Mitakshara, yes, it's a Mitakshara family. Obviously, not Bengali or Assamese, Ohmiya, so it is Dayabhag doesn't work, Mitakshara comes in. We all know that. But for Mitakshara co-parsonary to be formed today, the Vitakshara co-partiality to be formed today, what has to be seen first? First, it has to be that there has to be a inherited property from an earlier generation that has to come. How have they shown that? I say that they have not shown that. The carriage of proceedings is with them. They have to show, and they have to, if they want to intervene, because it's a suit between the brothers. If they really want to intervene clearly on each aspect, they have to show that each property which they are talking about and on which they are today enjoying an injunction for over a year almost, it was an inherited property by me. It will become, they will be entitled under the law of Vitakshara if the property has been inherited by me. If it is
it's your self-acquired property.
Some of them are self-acquired property, and some of them, what had happened, Your Lordship, because these families do business together, they were bought at the same time. They were bought at the same time. When they were all working together, thereafter the 75 deed, thereafter otherwise. That's why the brothers and sisters are dividing some parts of it. Now, which is of self-acquired property and which is, if it is carriage, that's why I say it's a carriage of proceedings on them. It is not for me to establish, oh no, this is mine, this is self-acquired,
So
this is
that
otherwise.
needs adjudication of the suit.
That may require adjudication, but that also first for them to be to intervene. They are not filing a separate suit. If they want to I say they have not even crossed the threshold of showing that they are ancestral properties.
What is the intervention application?
Lordship, intervention application is GA 17 of 2021.
That's your application.
Yes, Your Lordship.
So in order to attack this point, resist this application, you have to deal with chapter para 6 and 7. Para 6 and 7, they have worked out their locus standi.
Lordship, may I submit one thing?
No, not now. In respect of this application,
Lordship, GA 17 and 18 are my applications. Lordship, 15 and 16 are his applications. Let him make his submissions on 15 and 16.
let me understand the things.
Your Lordship will just look at what they are saying, how they have made out their case. They do not talk about properties. They say that in paragraph 6 that the interveners are sons of defendant number 1 and thus co-partners of the family of the parties. Which HUF? For big, Your Lordship.
This is your application, your Manish Agarwal.
Yes.
Where have you stated this? Where have you deal with this?
Lordship, Manish Agarwal is the plaintiff in CS2.
Your one is then Bhagirath Agarwal.
Mine is Bhagirath Agarwal, Your Lordship.
Where have you dealt with these paragraphs?
Your Lordship, I have dealt with in paragraph 9, page 10. I have simply denied it that they are co-partner in interest as alleged, because they are only saying that. They have given no particulars. Your Lordship, may I explain this aspect a bit further? When somebody, if with respect to, because the concept of HUF has got a lot of importance now, not really in the family law domain anymore, much in the income tax domain, because that is where the law has actually developed. So what happens is, supposing there is a family of three, a son, a mother, and a father. There can be today, after the change with the woman also being part of co-parenting, there can be three HUFs. Three. One, whether all three are in one HUF. One is the son and the father. One is the wife and the husband. Actually, four. And the wife and the son. There can be four HUFs. Each one can have a different co-parenting. Each one is a different co-parenting, Hindu co-parenting. What has to be said is not with regard to that I have a co-parenting. There is nothing called a co-parenting interest. I'm sorry. You are a part of a Hindu co-parenting, maybe Mitakshara co-parenting, actually not a Hindu co-parenting. What you have to indicate is that these are ancestral properties. Let's read. First, you have to indicate which one is an ancestral property. Then only have a right. You have no right over the father's or the mother's self-acquired properties. The basic law. There is nothing on traditional Hindu Mitakshara law. So what you have to show is that yes, there is a property that came to my father because their right comes through me. Cannot have an independent right over the main family. Their right is through me. So they have to show that there is a property whose interest, whether joint or full interest, comes through me from my ancestors. The ancestral property is in my hand. Now, what is their averment? In paragraph 6 and 7, as your lordship indicated, they say that the interveners are the sons of defendant number 1. That is not denied, obviously. And thus are co-partners of the family of the parties. No. Where? Which co-partners? Of which HUF? Have you identified? You have not even identified the HUF. But you are saying that you have something. Then says that by virtue of being co-partners of the family, of the parties, the interveners have got co-partnership interest in the suit property, and they have concern for preservation and safeguard of the joint family properties.
So your point is that although they have claimed to be co-partner, they have not specified any HUF.
Not only that, your lordship. Today, may I just explain? Today, there might be a family which has 5 brothers. Each brother has 3 sons. Each brother has 3 sons. Now, the eldest brother's sons, their rights are curtailed only to the interest of the eldest brother. So if the grandfather left a property, 5 brothers, there would be 20% to the father, the eldest brother, 20% to each. If that person has 3 sons, then that 20%
divided by 3.
By 4. The father and the 3 sons.
Yes.
By 4. That is the right. So they have to indicate. They cannot say some joint family properties are there and that's why I have some right. No.
So according to
because
you,
it is partitioned already. I say these were already partitioned. Many of them are partitioned already. So how they are emanating their rights?
So your point is that they are basically, since it is partition between the father, sister, and so others, they have not yet, father is still living.
Father is living.
So what they are trying to enforce is special successionists.
I'm not going that far perhaps, but yes, that is also true. But what I am saying is, your lordship, that to intervene, they might have a suit against me, not to disperse money, not to disperse anything, but they can't have a right over the entire set of properties in the family. Because first they have to establish their right. And there is nothing in law to say that I am a co-partner of a family. I'm sorry. You may be a co-partner of a Hindu HUF. Which property is being shown under the Income Tax Act, under which HUF has to be shown. That has to be pleaded. Nothing is there.
All right.
Bare particulars, nothing is there. That's why I have denied it. I am simply denying that you are a co-partner of who? Of which HUF? You are claiming to be, you have some right as a co-partner. First, you have to establish which property is ancestral at whose, in my hand, in my brother's hand, my sister's hand, together. were jointly bought. Supposing two brothers buy jointly a property, it is a joint property of a HUF, maybe between me and my brother and my sister, it may be a joint family property, but that's not an ancestral property. The essential criteria for an ancestral property is that it has to come from one generation before me. No linkage has been drawn. That linkage has to be specifically drawn for each property if they want to enjoy an injunction. All of these issues, Your Lordship, are completely mixed. They have given bare particulars, not even, and as I said, Your Lordship, the income tax returns, because even within the same family, they might be constituting different HUF, and each property might be under different heading under taxation book.
All right, got it point. Next day I will hear you. Next day I will hear you reply.
Yes.
And what about other applications?
My lord, may I indicate, my lord?
What about 15?
Yeah.
Let me come one after another.
Yes, D15 is my application, my lord, filed by the plaintiff, my lord. But before that, my lord, there is one application which is not in the list. GA14. My lord, if Lordship takes it chronologically, my lord, the applications which are pending.
Let me know the existing applications.
Yes.
When 14 is not in the list, I will not go into it.
Application for non-compliance, my lord, it's in the nature of Order 39, Rule 2A.
Order of attachment on the ground of
My lord, non-breach, my lord, committed, my lord, to an injunction order, subsisting injunction order in the partition suit, which was, my lord, continued and is still, my lord, in operation. In violation of that, properties were being sold, my lord. That's the reason this application.
all right. These are 14 and 15.
14 is, my lord, an application where, my lord, I am asking for substantive orders of injunction on the defendant number 1 with regard to the same Chevrolet Road property. His case, my lord, it's a partition suit between two brothers and a sister. His case is regarding that, my lord, partial partition decree is only in.
All right, I got this. Let the 14 come along with 15. I will hear next day.
Prayer, my lord, if 14 can also be listed on the next.
All right.
Whenever Lordship.
Next 16.
Lordship 16, it's not our.
16 is
16 is
Mr. Sinha's application
For
my lord, for recalling of that order by which, my lord, parties have been directed to, my lord, sell the assets and, my lord, distribute 1/3 each.
Next day I will hear all the applications.
Very well.
Because for hearing and disposing of all the applications, a report is needed.
My lord,
At least some of the applications I will dispose of.
my lord, directs the department to place, my lord, GA14 as.
কি বললাম last order?
Lordship, I am praying for extension of the interim order, Your Lordship.
একটু অর্ডার শিটটা দাও। GA number 14 of
21.
21.
In CS 283 of 2000.
All are in CS2, 283 of 2001. Shall appear along with today's application in the list. What is GA8?
My lord, 7 and 8, my lord, is in the other suit. Item numbers 19 and 20, where, my lord, Lordship had appointed, my lord, special officer. Lordship had already passed an order before taking up this.
That is, those are in
Different suit, Your Lordship.
2004.
Your Lordship, those are a different suit. This is a different suit. These will not, these.
7 and 8 can
So
be tried
two
on a
suits
different
for
day.
the time being for disposal of interlocutory application, I think, should be kept separate.
Yes, Your Lordship. They both are.
Yes, yes.
এটা কবে বললাম? এটাকে লিখে দাও CS ওখানে দেখো this is in CS 228.
Yes.
Yes, Your Lordship.
CS 228 of 2004 along with GA7 of 2023 shall appear in the list and GA8 of 2023 shall appear in the list on 21st February. যেটা বললাম ডেটটা। আর এবার লেখো GA14 of
21, Your Lordship.
2021 না GA দাও লিখে দাও CS 283 of 2001 along with pending applications shall appear in the list on.
Lordship kindly keeps it in the
You lost last week of February. Last week of it. Last week of February, anytime, last week of February.
Lordship,
We are
I am
ready to
being led by Mr. Somrat Sen in this matter. He is not available till the first week of March, Your Lordship. Lordship, the matter has been held up for a long time. Lordship, kindly keeps it.
To dispose of.
Lordship, kindly keeps it in the second week of March, Your Lordship.
I am extending you. I am giving you protection.
Lordship,
That's what it is.
I bow down to Your Lordship. The only thing is,
You have
Lordship.
two options. I can fix it in the second week of March without injunction order.
No, Your Lordship. Lordship,
Last week of February, my lord.
26th February.
Lordship kindly keeps it on 28th of February in that case.
28th of February.
March.
21 only only CS 228
Yes, Your Lordship.
and 283 along with the applications on that date.
Very well, Your Lordship. March of Black.
Lordship kindly extends the interim order, Your Lordship.
The interim order
dated 18th of January 2023, modified on 4th of July 2023.
passed on 18 January 2023, as modified in terms of order dated 4 July 2023, be extended till the returnable date, namely 28th February.
My lord has also directed GA 14 to appear on that. My lord, with other applications.
14 is 283. All pending applications.
All pending. Grateful, my lord.
Extremely grateful, Your Lordship.
একটাই অর্ডারে থাকছে সপ্তাহে। হ্যাঁ।
Item number 21.
But I appear on behalf of the plaintiff, my lord.
But I appear on behalf of the defendant number 3, my lord.
Also, I appear on behalf of the respondent number 9.
What is the status of the suit?
But if your lordship sees the last order, my lord, of 15th of December 2023, the 8th of January 2024, but there, the GA 19 was filed by the respondent numbers, defendant number 9, my lord.
3 against 9.
And against.
But there are mainly two applications, my lord. GA
Just a minute, one by one.
and GA
Defendant number 3. GA 19 is filed by defendant number 3. Who is defendant number 3?
I appear for the defendant number 3, my lord.
This is your application.
My lord, GA 19, 2023, my lord. We are seeking, we have prayed for an injunction against the defendant number 9, restraining him from selling of the properties, my lord.
Also, a property that I have received, I am for the defendant number 9, a property that I am a beneficiary of after a probate was granted by your lordship. So your lordship will kindly take up their application at page 12. Lordship, this is the order granting probate in my favor. So
Have
they
you filed AO
acknowledge.
against this?
Your lordship,
Have you filed AO against this?
no, your lordship.
He's appearing for the first time, my lord.
So you have to exchange your
Lordship
AO.
will file an affidavit in opposition.
But in
This
the
is
meantime,
19.
my lord,
This
This
is
is
19.
GA 19, your lordship.
in the meantime, status could be maintained, my lord. If he sells of the property, my lord, the
Your lordship,
injunction
there's
application will become infructuous, my lord.
Your lordship, I am the owner. I have been declared as a beneficiary. I have been granted a probate. Today, my learned friend says by this honorable High Court, in fact, this has been granted by your lordship.
Then
Your
what
lordship,
is
then,
the use of filing this application?
your lordship, this has been filed by the defendant number 3.
Then if you have that right, you can decide the suit also.
Lordship,
That cannot be.
Lordship, kindly up.
Because this court has to decide whether you have a right or not.
Lordship.
Your assertion is you have a right.
Yes, your lordship.
His assertion is you do not have.
Lordship.
That court will decide.
Lordship. But your lordship, this cannot be the assertion made by my learned friend subject to what falls from your lordship cannot be decided in this, because he in effect is challenging the probate granted, which we'll have to challenge by filing a revocation in of the probate.
Right.
He cannot come and assert this.
Absolutely right.
Lordship,
But
kindly.
if you have sold the property,
No, your lordship, I'm not selling the property.
it's your undertaking. You cannot say.
Yes, your lordship.
You cannot say.
Lordship.
Because
Lordship,
purpose of giving any status quo order is not to prevent you selling basically.
Lordship.
But the purpose is that the very hearing of application should not be frustrated.
Lordship, I'm not coming in the way of hearing the application. Your lordship may grant me
All right.
grant
This
me
is
an
19
opportunity
is
to
for
opposition.
order of status quo.
Lordship, they're praying.
What about the other applications?
There is, my lord, 22, my lord.
What is 22?
Application, my lord. This is, my lord, at the instance of defendant number 3, my lord. The plaintiff and the defendant number 3 were appointed as joint receivers, my lord. My lord, defendant number 3 is aged about 90 years, my lord.
Change him.
My lord.
To change him.
My lord.
Who filed this?
But defendant number 3 has only filed this.
Who is defendant number 3? You are.
But it's not possible for the defendant number 3 to look after the property, my lord.
Defendant number 6A to be appointed joint receiver.
File.
Your Lordship, may I only indicate two things? A, Your Lordship, in the meantime, these applications are pending. The defendant number 5 has passed away on 31st of
Who is
July.
the plaintiff?
But I appear on behalf of the plaintiff.
You have to take up
Yes, my lord. We do not have any information about that.
We've been informed that the defendant number 5 has passed away in the meantime during the pendency of the suit. So, Your
GA
Lordship,
22 of 24.
Lordship, I join issues. I am objecting to my learned friend only to the extent that a third party receiver be appointed. Lordship, any independent person, no one from the family, and any independent advocate can be. Your Lordship, the defendant number 3 is an
Just a minute.
85-year-old.
I am not passing any order, final order.
Lordship.
GA 22 of 24 is filed by defendant number 3. Praying for substitution of defendant number 3 as a joint receiver by defendant number 6A in view of ailing health and age of defendant number 3. GA 19 of 23 is filed by defendant number 3 praying for restraining order against the defendant number 9 from selling, transfer, convey, or create third-party interest in the property described as 15A Govindodhar Lane, PS Borobazar, Kolkata 1, and other properties. Any other application pending?
Well, these are the two applications.
Parties are yet to exchange their affidavit. Full stop. Affidavit in opposition against the applications are to be filed within 1 week. Semicolon, affidavit in reply, if any, within 1 week thereafter. GA 19 of 23 and GA 22 of 2024 shall appear in the list on 27th February. Full stop. The learned counsel for the defendant number 9, defendant number 3. Who is praying for Indian status quo?
Number 3.
3 prays for ad interim order of status quo during pendency of the application in respect of the property being premises number 58 লিখে নেবেন না এটা লিখে নাও Kolkata 1 as well as policy number. No, দরকার নেই Kolkata 1. That's all. Full stop. In order that the very purpose of filing the application is not frustrated by any transfer of title during pendency of the application, parties are directed to maintain status quo as to title with the returnable date.
Your Lordship may kindly hear me on this status quo application because they've not placed their application.
The
Your Lordship,
application
this is not a
not disposed of. It is
Lordship,
interim measure.
Your Lordship, I appreciate, but for even an ad interim order, my learned friend will have to show that he has some right title or interest in the property. So this is not a Your Lordship may kindly take up their application once. This is not a subject matter of the partition suit itself. This is a property of the defendant number 9. Lordship, they have not made out a case for any ad interim order. Your Lordship may kindly take up their application. Lordship, paragraph 5, they have not produced any evidence to show that I'm in the process.
How you are owner of the property?
Lordship, by
We are the owners of the property. We were the initial co-owners. The suit was filed by the plaintiff. We have the defendant number 3 has been made a defendant in the suit as a co-owner. Now, one of the co-owners have died, but he had executed a will.
Registered
will in favor of his sons and daughters. He has got probate of that will. Now, after getting the probate, he wants to sell the property.
Who are you? Who are you?
But we are the other co-owners, unless during the pendency of the partition suit, status quo be maintained, the very purpose of
Where have you stated that you are one of the co-owners?
That is the plain case itself.
All right. Once the probate has been granted in my favor, I become the owner of the
status quo for the timing. It's a very limited period. Come on the next day, I will pass full-fledged order, exchange your affidavit.
Lordship, may kindly appreciate today, I am the owner. Admittedly, I am the owner of the property. A probate is granted in my favor. I am the right. They did not oppose. They did not oppose the probate. I am the owner.
I understand. So I want to see the probate certificate.
Lordship, the probate order is there in their application. The order passed by your Lordship at page 12.
Good, bad, indifferent, they have become co-owners.
No, your Lordship. I am the owner. Your Lordship, by no. No, your Lordship. 22nd of November 2022, order passed in PLA 83 of 2009 by your Lordship.
Come on the next date, I will hear you. Because
kindly
whether this property has other ownership and all these things are to be heard.
Lordship, when there is an order of the court granting a probate in my favor, then your Lordship,
Tell me what problem will you face if I do not pass the order? If there is status quo order for 15 days.
Lordship, but they will have to also show their right title and interest in.
What problem you will have?
Lordship, even if I do not face a problem, but your Lordship will kindly appreciate they'll have to show their locus standard to get
I will
this
hear
injunction.
on the full-fledged hearing. I will pass order. This is for the time being measure, temporary measure, so that you do not change the proprietary title.
Lordship, it's very well, your Lordship.
Stopgap measure. This is only a stopgap measure.
Very well, your Lordship.
Come on the next date with affidavit. Hear the matter, because if in the meantime the property ownership is changed, you may have right. His application may be false. Ultimately, his application may be rejected.
Very well, your Lordship. In effect, he is challenging the probate, but this is not the forum to.
No, this is not probate. This is only a stopgap measure.
Lordship,
I have not passed any comment on anything.
Lordship, I follow what.
And you are party here. He is party here.
Yes, your Lordship.
But it is not that he is a stranger.
But if the property is not part of the family hodgepodge, then your Lordship.
Come on the next date with a
Very well, Lordship.
Next.
Item 22. Made with your Lordship.
Date বলেছে ওটাতে কি বললাম কি disposed of?
Your Lordship has kept the matter on.
Just a minute. 27 February.
Grateful.
Item 22.
May it please your Lordship. This is an application by me as the plaintiff.
Which application? So many applications are there.
GA number 37 of 2022.
What about 36?
I'm not too sure. Not mine.
Who filed 36?
Mine.
Is it pending at all?
I have to, my lord, I have to check up.
Lordship, I was waiting for the HDFC Bank defender number 57. We have filed our affidavit of document in terms of a Lordship's order.
No, 36 is possibly an order for recalling of order of Justice Banerjee.
I have to check up, my lord. I apologize, my lord. I should have checked up, but
that is a 2021 application.
37 of 22. What is this?
37 is mine. Now, this matter, my lord, this, my lord, involves frauds. We allege frauds
to which several defendant banks are party, as also, my lord, the private defendants. Now, my lord, the Central Bureau of Investigation, my lord,
Exchange of affidavits are complete.
yes.
Yes.
No, my lord, not this one. Now, my lord. Now, my lord, the Central Bureau of Investigation, my lord, has seized. I understand, my lord, 10 trucks of documents in connection with this matter. Now, my lord.
Was there any order?
Yes. Several orders. That's pending, still pending. Now, the thing, what has happened is, my learned friends, from time to time, they approach some of my learned friends, they approach the Honorable Supreme Court and obtain orders for expeditious disposal. You also want to get it disposed of because our officers also are retiring and all that. Now, unless these documents are there, my lord, I cannot proceed with the suit. Now, I had approached the CBI court, the jurisdictional court, for such an order. Such order was passed. In fact, I understand, my lord, one order is appended here, another order also passed after that. But nothing has happened. That's why, my lord, today I'm constrained to approach your lordship at page 24. Our notice of motion, lordship would kindly see direction upon the Central Bureau of Investigation to supply certified copies of those documents. Because without these documents, my lord, I cannot.
Documents are in custody of the learned judge, 3rd Special Court, Kolkata.
No, custody of, I understand, custody of CBI. We had, the matter is pending before the learned.
Who are the custodian of document? Whether the court or CBI?
CBI.
They have filed it in the court or in
They have not. They have not filed it. Lordship would kindly come to page 83. No, yes.
Alternatively, you file an application calling for the document.
Lordship.
So that I can pass order to the CBI to furnish copies of those documents. Because they are investigating into the case. They may not part with the documents.
Subject to correction. Subject to correction, lordship is thinking of probably subpoena, something in the nature of.
Because during the stage of the investigation, they may not part with the documents.
Because the order is already there upon them. Lordship would kindly see at page 83. That's not annexed here anyway. We can.
Now, when this court has passed the direction, I cannot, having an ordinary civil jurisdiction, I cannot say this.
No, lordship is definitely not sitting in appeal. And lordship would kindly note in the penultimate paragraph.
27 also.
No, not at all. Not at all. Lordship would kindly say at the penultimate paragraph, learned
direction is given.
Yes, learned senior PP submits. They have no objection also. But
still things are not done.
That's why, my lord, we are constrained to approach.
That's why the constraint is this court is neither a writ court now nor appellate court. So I cannot enforce upon CBI to do this. You have to file an appropriate application before that court or 227.
I thought this is the
I am
most efficacious remedy, if I may put it, my lord, that way. Because
even if
the season is, lordship would find from page 37 onwards.
I understand.
Yes.
I understand your pain also. The issue is that I cannot pass that kind of order. Because that would be tantamount to supervising a court.
May I then, what my learned junior Mr. Ghoshal rightly points out that it's not really even a supervisory capacity, probably, my lord, in the aid of suit, in the prosecution.
What I can do,
yes,
when there is an order,
lordship.
Certain document XYZ documents are there, you file an application for calling for these documents.
I will then, my lord. Then, my lord, may I suggest this subject to lordship's kind convenience? This application will be kept pending, and in the meantime, I will take appropriate steps.
I'm simply adjourning it.
Defendant number 56, my lord, I've already given notice for inspection. Nobody came for inspection. I'm paying for some more time while judges report.
More consequences, but without these documents, my lord, what?
I'm adjourning this.
Yes, great. Much obliged.
Adjourn to 5th March.
Great.
Grateful, Lord.
Much obliged.
23.
And for the defendant number 2, my lord. For the plaintiff, my lord, the application made by the joint special officer, my lord. The declaration of the defendant officer of the defendant, my lord. Actually, on the special officer.
What about this GA? GA,
G12.
GA12 is for?
G12 special application for the application made by the joint special officer.
My lord, I'm for the income tax. I'm praying for not today, my lord.
My lord, appeared for first joint special commissioner on behalf of Mr. President. Please advise, my lord. I'm praying for.
What is the status of the suit?
Several application, but pending in the Supreme Court, my lord.
On prayer of the learned counsel for the special officer. The matter is adjourned to 19 March. Affidavit in reply filed on behalf of your petitioner be kept in the record. Thank you.
March.
Any day after this week. I wanted to come on Friday, but before কবে হচ্ছে 14, 15. Well, it gives you 16th, then I'll come on 16th, 17th. 19th. Any day, 19th or 20th. I will finish it that day. I'll come with the note. 20th. Yes. I'll come with the note and I'll just simply submit the note and take mileage leave. My lord.
Item 25.
Sir, we had concluded our argument. May I file my notes?
Any notes of argument?
But I have already filed.
I have already filed, my lord. I am filing today. I'm grateful to. It is me.
My notes of argument filed by me, my lord, let me kept on record.
Yes, it was already, that order was already dictated. Because 3 dates ago. Grateful to my lord. My lord had given us a very patient hearing.
It is to be given.
My lord.
26
and 27.
26 some लोग हैं. Lordship, I am for your lordship the plaintiff in one of the matter. I have filed
ICICI.
Yes, your lordship, in suit 435 of 1985.
Name yourself. ICICI or Satnaliwala?
Satnaliwala.
You are Satnaliwala. You
Yes,
are
sir.
ICICI.
We filed one application, your lordship, on the last occasion. There's a direction upon them to file an affidavit. I propose. Suppose no affidavit has been filed.
Affidavit for?
May I move the application, your lordship, kindly? Very short.
This should go to the commercial division.
This is recovery of.
It cannot technically go to the commercial division. My lord,
recovery of possession.
Recovery of money.
Recovery of money.
Recovery of money.
Then
From
definitely it will go to the commercial division.
The principal claim is
Where
much
is the
less.
claimant?
My lord, on the last occasion, your lordship was pleased to grant me the leave to file my affidavit in opposition. I am slightly out of time.
Affidavit in opposition against?
Against their
my
application.
What is your application?
Lordship, my application, your lordship, is only allowing your lordship the witness to adduce a further evidence, because your lordship, in the meantime, what happened, your lordship, during the arguments, your lordship has reframed the issues, and one of the issue, your lordship, is whether your lordship the partnership firm is a registered partnership firm or not. So I would be hit by section 69 of the Partnership Act. Now, if your lordship kindly takes once, when this initial
My affidavit in opposition draft is almost prepared.
let me just complete it.
All right, that will be
I'm
allowed.
praying for extension. I'll offer little time.
All right, but before that, let me see whether it will go to commercial division or not.
Correct.
Possibly to commercial division. Because money claim in course of business.
4,32,000. This is the house, no?
Of course, not a personal loan.
No. And this is arising out of a tenancy agreement, your lordship. The nature of the suit, your lordship, may not fall, your lordship, within the purview of commercial dispute, your lordship.
Why?
It's a recovery of money, but not in respect of your lordship the loan, or your lordship is finance agreement, not
agreement relating to immovable property.
Yes, your lordship.
Used for commercial purpose. Used for trade and commerce.
Used for trade and commerce, but
agreement relating to immovable property. This is the license agreement or whatever you may say, that is related to immovable property, and that immovable property was used. Come to this one.
My lord, principal claim. Here, principal claim
Column 18.
4.52 lakhs.
7.
7, yes.
Agreement relating to immovable property used exclusively in trade and commerce. But your lordship, if your lordship sees the relief, your lordship is not
Question
in connection
relief.
with the.
It is enforcement or related to agreement.
As your
Because
lordship
if I
thinks-
pass any order in these jurisdiction, that might be infractuous.
Infractuous, not beyond.
Because
without
look,
jurisdiction.
this judgment will go against any of them on appeal.
As your lordship thinks, your lordship can transfer this matter.
But my lord, pecuniary jurisdiction.
What is the claim?
My lord, 4.52 lakhs. It was the claim of
No,
my
at
learned
that
friend.
point of
At
time,
that
your
point of time-
1985, your lordship, the
It is now 3
Honorable
lakhs.
High Court at Calcutta, your lordship has the jurisdiction.
But with Calcutta High Court, it has to be more than 10 lakhs if it has to go before
3
the
lakhs. Commercial
before
court
the
division,
commercial
3
division.
lakhs. 3 lakhs is now commercial
Well,
court act.
3 lakhs for subject to correction by your lordship. 3 lakhs for city.
Now, if it is 4 lakhs or something like that, then this court will have no jurisdiction at all.
No, your lordship. Now, your lordship, when the suit was filed, at that point of time, it was your lordship 2 lakhs. Then after your lordship, time to time, pecuniary jurisdiction has been enhanced. Subsequently, it was 10 lakhs.
85 suit.
Yes,
Yes,
85 suit.
85 suit.
So this court will have the jurisdiction. This court retain the jurisdiction.
My lord will
Suit
have
was
the
filed
jurisdiction
before
in non-commercial division.
And even in the commercial division also, the lordship, the Honorable Calcutta High Court has the jurisdiction in connection with 10 lakhs, not 3 lakhs.
Yes.
That's why we have a notification.
Vis-a-vis city civil court, it is 3 lakhs. But as regards Calcutta High Court,
The city civil court, they don't have any commercial code. Till date.
Separately
is going to be established, but কোথায় হয়েছে? কোথায়?
এখন ওদের city civil court
হয়নি এখনো।
এখন ওদের city civil court
হয়নি এখনো। কোথায় হচ্ছে? Where is the commercial
Anyway.
division? আসতে দাও।
All right, I will check it.
Yes, your
I'm
lordship.
not passing any order today.
Yes, your lordship. Lordship, only one thing, your lordship, in connection with my application.
AO, yes, it's sitting time for AO. On prayer of the learned counsel for the defendant, time is extended for filing affidavit in opposition against GA8.
GA9, I believe.
GA9.
GA9 of 2024. What about GA8?
GA8, your lordship, is not our application, your lordship. Long, I think these are all pending applications since.
GA8 টা দেখো তো
এটা
ওটা নিয়ে নাও। Yes, GA8 is for early hearing of the suit. Early hearing of the suit.
May be disposed of, your lordship.
কি বললাম? Full stop. GA8 is was filed for expeditious hearing of the suit. Since the suit is taken up for hearing an argument, GA8 of 2020 stands disposed of. Fix. February 20th for hearing of GA9 of 2024.
Well, time to file the affidavit in opposition be extended.
Yes, I have passed that order. Affidavit in opposition shall be filed within 1 week and affidavit in reply within 1 week thereafter. কবে ডেট বললাম?
20th February, your lordship.
হচ্ছে না তাহলে আজকে হচ্ছে 8 তো 27 February.
27. Come back.
Item number 28. Damodar Valley Corporation.
অর্ডার শিটটা দেখি। None appears. On previous occasion also none appeared. Let the suit be dismissed for default.
Witness action. Item number 29.
Appear for the plaintiff, my lord. My witness is here for cross-examination. May I proceed? John.
Shown answer to question number 247. একটু deposition একদম last answerটা যেটা। Last answer.
এই রেকর্ডটা পাঠিয়ে দেবে। কোনটা বলতো প্রাচীন রেকর্ডটা?
Two 247 তো?
Yes, my lord.
You have deposed that the defendant had agreed to vacate the flat and it is recorded in one of the documents, oblique letters, full stop. Can you say what is the date of this document, oblique letter?
Yes, I think it is 27th of November or
please be a bit louder.
24th of November.
Be a bit louder. Speak
27th of November or 24th of November. I don't remember, but this is I have disclosed.
Answerটা কি গেল?
Year I don't remember.
27th or 29th November, year I cannot recall.
It must should be prior to 94 or so. It is there, man. Most of the things have happened between January 90. এখানে থাক না। এখানে আমি January 90 and November 94. If I'm allowed to see the brief of documents, I can identify.
Yes. You have also deposed that the defendant had agreed towards adjustment of occupational charges if they do not vacate. Full stop. Since when is the defendant and or his family occupying the flat in question?
See, when the building was under construction and when only the structure was raised, even the
boundary walls of the rooms were not erected. At that time, even the entrance door to the flat was not fixed. He not defendant, his father-in-law, because I have never dealt with defendant. His father, his sorry, was not fixed. It ended only a temporary wooden plank plank was fixed to use it for locking the entrance. The key was handed over to the defendant's father-in-law to enable him to have the insight of the flat, construction, layout, material, doors, material, the placing of doors and windows, etc. And also the flooring, whether mosaic or marble of his choice, and of his choice. On condition that he will pay the extra amount for that. And it was in good faith that some money on account advance was received because he was very keen to have the flat for the simple reason that he means his father-in-law, S.S. Gupta, had his own residential bungalow. His residential bungalow in Alipur Park Road at 8/2, premises number 8/2 C, which was very close to this building. And he insisted that he will pay the on account he will pay the on account money as he has enough funds from his tea garden and he gave reference of his grandfather-in-law, maternal grandfather-in-law, Mr. Nandlal Kanodia. Maternal grandfather-in-law, Mr. Nandlal Kanodia. Who was resident of the next door house and who happened to be one of the trustees with me in a public charitable trust. And they knew that we honor our commitments and words. And we have a very rich heritage of enjoying great reputation in that regard.
I'm going to question the question.
My lord, I'm giving the long answer, which is very necessary because I'm telling the truth of the matter, why it has happened.
No, what I off the record, huh? I am asking you the question as to the date or the time. I know your answer might be relevant. Please answer the question and thereafter you volunteer whatever you have to say.
Okay.
So, I mean,
It was.
let me just frame another question. Can you mention the date from which the defendant number one and or his family and or his father-in-law was occupying the flat in first floor of premises number 3B Ashoka Road, Calcutta 27?
Sometime between 84 and 85, 1984 and 1985. Exact date will appear from a letter where which shows that key of the temporary entrance door entrance of the flat was handed over to Mr. S.S. Gupta's representative in good faith. While payments were on account payments were being made in the belief that the honorable negotiation will materialize into a final deal. Yes.
Can you on the next date mention the date of this alleged letter and also whether it has been disclosed in this suit or not?
Yes, definitely. I'll be able to disclose. And whether it has been disclosed in the suit, I don't remember because here it is a case of defamation. And my case is not relating to the deal or transaction.
Your question put to you is that whether you will be able to file or you're able to say or not.
Yes, yes.
Your answer will be limited to that extent only.
Yes, my lord. Yes.
Be precise.
Yes, my lord. Yes, I'll be able to. It is there. It is there.
You have stated in 1984, 1985, possession of the concerned flat on the first floor of the concerned premises was handed over to the defendant and or his family. Can you say when the amounts were paid by the defendant and or his family?
Yes, it was between 1984 and 85. It was between 1984 and 1985.
What was the quantum of money that was paid by the defendant to you?
The money, exact quantum, I don't remember. I have to check up. I can tell you on the next date.
Very good.
But I want to add one thing. The money was paid. Money was paid from two companies who are.
Next day you will tell. You said next day you will tell.
Yes.
That's all.
But only one thing. In one of the company, the money which they had paid was refunded also.
Did you finally?
And we said that the account deal is since cancelled or whatever negotiation taken place, states. That was with regard to one of the company out of the two companies. Those letters are also there. In two installments, these monies were refunded. Entire money. Which that company has paid. Basundhara Commercial. Basundhara Commercial. Yes. Yes.
My lord will kindly grant leave to Mr. Ghosh to continue. এটা থেকে বললাম, ও বললো মনে করতে পারছি না।
Would I be correct in saying, nah, কেটে দিন. Is it true that after 84-85, when the defendant and or his family enter into possession of the flat in Alipur, they had started requesting you for a formal conveyance to be executed in that regard?
No, that situation could not arise because after some time the real color of the hot temperament, wild behavior.
Mr. Jhunjhunwala, this will go on.
No.
Please, one second, with the leave of honorable court. Please listen to my question.
But this is a very
No,
relevant.
no, please,
My
please
lord,
listen
this
to
is
my
very
question.
relevant.
Question
Very
time.
Mr. Jhunjhunwala, this is cross-examination.
Lordship.
So you answer what is
You
really
cannot
not
go on saying
relevant.
whatever you feel
It is
like.
to veracity
Please
of your truth.
answer. Questionটা
Lordship.
পড়ে দিন ওনাকে.
They had started requesting for a formal conveyance to be executed in that regard.
No.
That is the
That-
question. Did
no.
they request or not? What happened? True
Your
color
answer
comes
is
later.
either yes or no.
Did they request you for a conveyance or not? That's the question. Yes or no? You may not have granted it. Their true color came. That's a different thing. Did they request or not? That's my question. Ever, in writing or otherwise?
My lord, to answer that, either yes or no, will be something where we will be misleading. Because the way things went, their behavior, they had no moral right to ask for.
That is not
Question
my
is
question.
moral right. Question is whether you have.
They asked it you or not.
No,
No.
That's all.
not legally.
Not legally.
Not legally.
Did they ask you in writing or verbally about the conveyance? The question.
Whether Mr. Jhunjhunwala, they may have right, they may not have right. We are not going into that. His simple question, whether you are asked or not.
They may not have had a right, but I am asking you, did they ask you?
No, he did not. No, let me clarify. Mr. Gupta did not deal with me directly. He dealt with my colleague, Mr. Ramkishan Agarwala. And I was the person to receive the Agarwala.
Mr. Gupta bollen. Mr. Gupta.
Mr. Ram. And I was the consular attorney and advocate to receive the money.
Who is Mr. Gupta?
Not Gupta. Ramkishan. Oh, which
You said Mr. Gupta.
Mr. Sham Saran Gupta, father-in-law.
Say that.
Sorry. The Gupta, father-in-law of the defendant.
So you do agree that the defendant and or his father-in-law approached via media or otherwise to you for a conveyance in respect of the said flat in or around or after 84-85?
No, he did not approach me.
Yeah, আগের আনসারটা একটু পড়ুন তো। এর আগের আনসারটা একটু পড়ে দেবেন।
No, he did not approach me.
এর আগেরটা।
He did not approach me directly. He did not approach me directly. He did not approach me.
ছেড়ে দিন, দরকার নেই। So they must have, the defendants and or the defendants, the then father-in-law had approached via media to you for a conveyance. Is that true?
I can't say that. I'm not aware of that. What discussion took place? I'm not aware of that.
Discussion. Complete the answer.
What discussion took place between Shamsuddin Gupta and Ram Kishan Agarwal?
এটা 36 হবে।
I'm not fully aware of that.
এটাকে ইয়ে করো।
Who is Ramkrishan Agarwal?
He is one of the party defendant in the suit which Mr. Shamsuddin Gupta and his companies have filed in Alipur court. Have filed in Alipur court for the specific performance of an alleged non-existent agreement for sale.
When was this suit filed? In Alipur court for specific performance?
It was filed sometime in 94 after we have filed our suit for eviction.
So when, according to you, did altercation start between you and the defendant and or his family with regard to the flat in Alipur? And full stop.
Can the question be repeated?
Yes, of course.
Altercation
Yes,
or discussion, what you said?
Altercation.
Altercations started. Altercations start between you and the defendant and or his family with regard to the flat in Alipur.
First time. First time, when did it start? First time.
It was sometime after 85 to January 90. During this six weeks, it went on.
Right. 84 to 90, right? 85 to 90.
End of 85.
What were the nature of these altercations between you and the defendant and or his family from 85 to 1990? And why were there altercations?
The defendant and particularly his wife were very hot-headed in their conversation on any matter, as if they are of superior status and they are obliging us by paying the money and on account money, paying the on account money and on small matters like parking of cars, use of the rooftop, use of the roof or the lawn, they would roof or and opening of the gate, entrance gate, after midnight. They would raise their voice, and talk in a bossing manner as per the understanding which was there. With them, they were not entitled to use. They were not entitled to use the roof or the lawn or any other place for parking of the car except the earmarked place for car parking. And that led to lots of trouble, physical violence, and that ultimately, ultimately on midnight of 31st December, 90. No, 31st December 89. When defendant returned to Ashoka Road, 3 Ashoka Road, returned to Ashoka Road after in a drunken condition. He had abused Nepali Darwan who was there, Man Bahadur. Nepali Darwan. Abused Nepali Darwan, Man Bahadur. And had thrown the chair on him. Because there was some delay in opening the entrance gate to allow his car to enter. The Darwan was injured. He was medically examined and complaints were lodged with the police. These are all on record. All. One more sentence. The building was constructed by with my help by Mr. Ramkishan Agrawal. No, by Mr. Ramkishan Agrawal. As the land was purchased by me as consular attorney of Mr. Agrawal and other 3 co-sharers from the father and from the father of Mr. Tarun Bose and his brothers. Mr. Tarun Bose, from Mr. Tarun Bose, senior barrister, and his elder brother, who trusted me to sell the vacant plot of land and not to anybody else. And that's why I was inducted and given the responsibility, which I accepted.
And given the response.
Thank you. I'm sorry the question is a little longer, but I couldn't.
The question is not longer.
No, sorry,
answer
answer. I'm very sorry.
Question was very short.
No, my answer. I'm very sorry.
Mr. Ghosh, how many questions should you ask like this?
I have to ask something.
I'll make it short now.
No.
I'll make it short now.
So, would I be correct? No. So, relationship between you and the defendant and or his immediate family members were already strained by the end of 1990. By around 1990, because of the altercations and the high-handed attitude of the defendant and or his family members. Am I right?
You see.
No, please answer yes or no, and then you go on to give your explanation. Please answer yes or no. It's a simple question. Please read out the question to him once more.
I can't answer in yes or no. Because, yes. Let me very.
No, first you're not even listening to the question, sir.
Yeah,
No, please tell me what is the question. Oh, 1 second. Please tell me what is the question.
Hmm.
And the defendant and his family members were already constrained by
Strain.
by the gains
By 1990.
gains of 19
No, by 1990.
because of the altercations and hard-handed attitude
Of the defendant and his family members. I'm agreeing to what you're saying. So please listen to the question before you say yes, no. That will make life easier for all of us.
It is very.
Read the question.
No, I understand the question.
Then?
But what I say, you may one way yes, but it was not attributable to me. It was not attributable to me. Attributable to me. In spite of that, I maintained high grace, honor, and dignity in my dealings. And defendant knows in his heart of heart.
And knows this in his heart of heart.
That he can't give a single example or instance that I have in any way dealt with him in a behavior which is unbecoming of a person of my status, being a professional of high value.
Whether your answer is yes or no.
Yes, in a way. That's yes, in a way. Yes.
Next question.
So, according to you, although you maintain dignity and grace, the defendant and or his close family members continued to behave in a high-handed manner with you and your representatives and the staff of the building. Am I correct?
Yes, my lord. This is perfectly correct.
And this continued, according to your deposition today, from 85 to 90 and even thereafter. Am I correct?
Not it, not it, 1985. After
That's what
1985.
I said.
After 1985.
From
But
1985 onwards,
it came to surface in 89.
89.
Yes. It came to surface in 1989. And it still continues. It still continues.
So, I suggested to you that since according to you, you were subjected to high-handed behavior and arrogance from the defendant and his family members, despite you maintaining grace and dignity, being a part of the profession, you were continuously being harassed mentally by the defendants. In a way, mentally, were harassed by the defendants mentally, 1990 or thereafter, 89 onwards.
Yes. Till the time he stayed there.
89 onwards, till the time he stayed there.
Till the time he stayed there, because.
No, just
but
because, yes,
no,
that's it.
No, very important. But continuously by his wife.
Continuously
by his wife. Huh. Which is still continuing.
Which is still continuing.
And defendant was driven out of the house by his wife.
Exactly. Wow.
And probably long back, maybe up to 20 years back or so. I don't remember. And and probably they are separated by divorce. I don't know the details. But he's not allowed to enter the premises by his wife. Huh. He is not allowed. Huh. His wife. His wife. Nandini, Rajanandini Patricia. Who?
Unnecessarily, don't go on. I've asked you.
No, I have. This is very important. This is very important. Who? Herself is a divorcee from her first marriage.
You can't stop him from saying.
No, these are very material.
That's what I'm saying. I cannot stop you from saying.
This is the rich man.
So,
the wealthy people, they can afford to do that. You ask, in his heart of heart, let the defendant.
Mr. Ghosh, you will be confused.
I'm very clear in my mind. My junior is poking me, saying that since you are wealthy, I said that proves I'm not wealthy. I have only one wife.
This is not the reality.
Now,
my lord.
Forget it. Let's come back to the matter.
Why the defendant is driving?
Next question. Don't go into all this. So I suggested to you that by So, by 1993, this high-handed behavior of the defendant and or his family member and his wife, which started from 89-90 onwards, must have escalated and must have become more unbearable to you, being a man of high stature and repute.
No, not because of high stature.
No, please.
As a human being.
Please listen to the question.
No.
কি বলছে?
No.
I have a question টা পড়ে দিন তো নাকি? না,
So I suggested to you that by 1993, this high-handed behavior and his family member, which started from 1989 to 90.
No, 89 onwards. It started from 89 onwards.
Must have discouraged and must have become more unbearable to you, being a man of high stature and repute.
Yes, not because of high stature repute, but as a genuine human being.
Correct. I agree.
Human being. It was offending to your self-respect. In spite of that, to your self-respect. And in spite of that, I didn't enter into any quarrel. I didn't enter into any quarrel. Huh.
So now I am suggesting it to you that because of this situation that you have mentioned in your deposition today, you had thought of and in fact executed this plan of filing the present suit, feigning that an alleged incident of defamation happened on 27th May 1993, just to teach a lesson to the defendant.
No, totally false. Totally false. It has no connection whatsoever. It has no connection whatsoever. I repeat. As a matter of fact,
Next question.
My Lord once said, as a matter of fact, his maternal
Yes, we have denied that. That's all.
grandfather-in-law has come and apologized and tendered apology to me.
Whereas I suggested to you that no other eyewitness of the incident incident of alleged defamation on 27th May 1993 or that happened allegedly in the chambers of Khaitan and Company will come forward and corroborate this fact on your behalf in this suit. What do you say to that?
No, there are witnesses, yes. My son is there, Ravin Junjunwala. Then the neighbors staying in that building, they are there. They were there.
My question is, will they come and depose? Please listen to the question.
Yes, they will. At least, though.
Who all will come? Give the names.
Ravin Junjunwala,
সবকটা নাম লিখবেন না, শুধু যাদের নাম
Ravindra Junjunwala,
শুধু যাদের নাম বলছেন এখন তাদের নাম লিখুন।
Ravin Junjunwala, and Shekhar Mukherjee, who was present there, and those amongst those who are alive, maybe Tarun Haldar, Devchand Jha, Jha, and Maan Bahadur is dead, Ajit Datta dead, and the neighbors in the building, Narayan Agarwal, Ramkishan Agarwal, they all were there. It went on for.
The question is, who all will come to depose here, not who all were there. Mr. Junjunwala, you are unnecessarily carrying on.
Two of them, Ravindra
So
Junjunwala,
please give those names.
Ravindra Junjunwala, and Shekhar Mukherjee.
শুধু এই দুটো নাম লিখবে, আর কারোর নাম লিখবে না।
But my Ravindra, he can do that on video conference only. Because he is doing international work, he's all the time traveling.
He can appear.
I have the documents with regard to that.
Please don't.
Next question.
Ask the Honorable Court's permission. You cannot look into any document unless the court allows you.
Lordship.
You know that, Mr. Judge.
May I show it to your Lordship?
Not at this right time.
Lordship.
In proper time, place the document and seek for permission.
How old was your son on around May 1993?
He was about 21 years.
21 years in
20.
1993. The son is younger than you. How old is he now?
He would be about 51, 52. The year birth is 1973. Early 1973.
Lord, may I stop here for today?
PW1 is cross-examined in part. Further cross-examination is deferred to. When will you be able to come?
Any day, my lord. Tomorrow.
কালকে কি আছে?
My lord, only one thing. There was one confusion on the on the occasion of when I was doing the examination in chief regarding the documents which were brought by the plaintiff from the Alipur court. Your lordship remembers that. My lord, when I have put the question, those documents had to be returned to the Alipur court. So there was a confusion. So it went in as subject to objection. The plaintiff has brought those documents again from the Alipur court for examination. So, my lord, if the defendant wants him, once he can
look into this today, and I can take a call.
They come next day.
Yes.
Huh? 12? Would you be able to come on 12?
Yes, my lord.
12 February. 12.
Item number 30 and 31. But I'm for the plaintiff.
I'm for the defendant.
But we have prepared the judge's brief of documents. Voluminous.
PW1 is there? The witness is there?
No, that witness is not there because Lordship would definitely fix a date because he's an old man. I told you, Lordship, and the medically not fit at all. So Lordship fixes a date and time. He will come and we will adduce evidence before the court. I'm not seeking for any commission. He will definitely come to court, and because that would also be cost. If it would be a cost.
Will be able to come.
But Lordship fixes a date. I will ensure that he comes on that day. Otherwise, he is available, but he is not well. So he will. That day he will come.
Document is produced.
Yes, that I have handing over.
That is for the plaintiff.
For the plaintiff.
Additional.
Not plaintiff. This is a combination of documents.
Judge's brief of documents are produced today. Witness action is adjourned to 28th February.
Very well. But can it be sometime in March, where that day I have a, if it in the month of March. 5th March. 5th March. 5th March. But can it be on 6th March?
All right, 6th March.
6th March. And would you lordship kindly fix a particular time? Because an old man.
Second half.
Second half. So he'll come at 2 o'clock. And that one more thing, the next matter, this suit is a composite suit. One of the properties involved in the next matter as well. That matter evidence is already complete and documents have been exhibited. But Mike, I want to lay on the exhibits of that suit in this suit.
File an application.
But I will file a application for relying
because
upon
those two suits are different.
No, analogously hard.
Analogously hard.
Yes.
So common judgment will be passed.
Yes. So I'll be relying on
pass order. I will pass order that this exhibit of this CS so and so shall be relied upon in this case.
Yes, for that I have to make a one-page application. Yes, but I will.
You make out which documents you want to be marked.
Very well. The exhibit with exhibit numbers I will indicate and very well. Grateful.
Those will be treated as exhibit in this case also.
Yes. Grateful.